not working.
Yeah, like 6 calls.
Yeah?
Okay. I thought we were gonna have more, considering it was gonna be 70+ degrees.
Yeah, right. You know, it was so foggy today. It's
It
like
was.
it's like you wake up and you think I'm in a M. Night Shyamalan movie.
Yeah.
You know.
Hey, Mark.
Hi, Rich. How are you?
I'm doing well.
Good.
Why am I
Good.
seeing you?
Why are you seeing me? I don't know. It's supposed to be 10 o'clock with Judge Haynes.
Right, that's what I thought.
In this, he's gonna come sit in this seat.
Okay, so do you want to blank me out or something, or?
Sure. Okay. Hold on.
Should I
We're
be
getting used to
doing
the.
something?
All right, let me go. I'm trying to figure this out.
Yeah, nothing's going to happen in the Terrell case until 9 o'clock, Rich.
Okay, so what
10 o'clock.
should I be doing?
I'm sorry. You want to call back at 10, or do you want to just? I mean, you're welcome to stay there. You can mute us out if you want.
No, I'll mute you guys out, and then, you know, when it's my time, I guess I'll at 10 o'clock, I guess I'll log him back in, right? Is that the way it works?
Oh yes, of course. Okay. Yes, of course. Okay. All right. I guess I got to talk to her first. Let's get up Devin Webb. Oh, you know what? Yeah. Hello, Devin Webb.
Yes.
All right. Good morning. Bear with me, Miss Webb, because the microphone is not that good at the Atlanta County Jail. All right. If you can't hear me, Miss Webb, raise your hand, give me a wave, let me know somehow that you can't hear me or that it didn't go through, okay?
Yes, sir.
Okay. Now, I don't know if you can see, but the prosecutor is present, the public defender is present, and this is your first appearance. I'm also going to have first appearances for some of the men at the Burlington County Jail, but I'm waiting for those guys to come in. So while we are waiting, let me just tell you about your case. The case number is W 2020-144-317.
Microphone is muted, Your Honor. You're muted, Your Honor.
I have a lawyer. I shouldn't have a public defender.
This is just for your first appearance, though. I guess I don't know.
Yeah, I had a lawyer for my other. So this is my first appearance.
Oh.
I had my lawyer the first time.
Can't hear you, Your Honor.
I can't hear you, sir. Oh, Your Honor, I'm sorry.
Okay. Now, did you just unmute, Rich? No.
I can hear you now.
Okay. We're just having a challenge with the equipment here. Why did that happen? How did that happen?
I don't know.
Okay. All right. Okay, Ms. Webb, your case is W 2020-144-317. 2 charges, domestic violence in nature from March 17th, 2020. One is simple assault, that's a disorderly person's offense. The other is burglary, a 3rd-degree offense, by pushing into the residence without the victim's permission. You understand those are the 2 charges, Ms. Webb?
Yes, sir.
Okay. Let me indicate to you that you are presumed innocent of those charges unless you plead guilty or you're found guilty. You also have the right to remain silent. Anything you say can be used against you. You also have the right to have a lawyer represent you at every stage of the proceedings. You can always hire an attorney. Have you hired an attorney? Tell me about that.
Yes.
I have a lawyer.
Who is that, please?
I can't tell you the name because all of my information comes to my mother, but I do have a lawyer.
Okay. Is that lawyer expected to be involved in your case today, Ms. Webb?
Judge, I can
I
offer
was
some light
assuming-
on that.
Okay, Mr. Prosecutor?
Yes, Your Honor. I believe Michelle Finizio was representing Ms. Webb. I actually had discussions with Ms. Finizio yesterday about the case, and it's my understanding we reached an agreement as to Ms. Webb's release.
Okay, do you think, is Ms. Finizio expected to log on and be involved?
She advised me yesterday that she would be available via cell phone. I spoke with her yesterday afternoon when it was a little bit up in the air about what we would be doing today, and she said she would be available via cell phone.
Okay. Do you have the cell phone number?
I believe so. Let me check it. I believe I put it in the file.
All right. We don't need it immediately, but we'll need it soon. All right. So Miss Webb, you do have attorney Michelle Finizio, and Mr. Prosecutor, is this a matter that's resolved?
Yes, Your Honor.
Okay. So Ms. Webb, your attorney spoke with the prosecutor, and they worked out a resolution so that you will be released with conditions. Okay. All right. But let me just tell you a couple more things because there's some information that's very important for you to know. All right. So you have a lawyer. If for some reason you don't have that lawyer anymore, you can always apply for the public defender. You have to fill out an application. Ms. Finizio is your lawyer now, though. When you get a chance to talk after the detention hearing thing that is not going to happen for you, after you're released, you should talk about two programs, drug court and pretrial intervention. They may help you resolve your case, drug court and pretrial intervention. You also have the right to have the grand jury hear the prosecutor present your case for possible indictment, and ultimately you have the right to a jury trial. You can waive an indictment, you can waive a jury trial. Do you understand all that, ma'am?
Yes, Your Honor.
Okay. If you're released, which it looks like you will be, there will be conditions. You'll hear me say with those conditions. You're going to hear me say some of these things over again to the men at the Burlington County Jail. Just hang in, and then we'll get to you with Ms. Finizio on the phone. I have a quick question for you, two quick questions. Are you a United States citizen? Are you a citizen?
Yes, Your Honor.
Yes? Okay. And are you a military veteran? Did you serve in the military?
No, Your Honor.
No? Okay. There's things I would have to tell you additionally if they applied, but we don't have to worry. Your court date, ma'am, is on, I just got rid of the court dates. Oh, here it is. Your court date is on May the 6th, and that's at 9 o'clock here at the Burlington County Courthouse. You'll go to courtroom 7A, which is the top floor, 7th floor, 7A. You'll see Judge Covert, and that's for not a trial, that's for a pre-indictment conference to see if you can resolve the case before it might go to the grand jury. You understand that?
Yes, Your Honor.
Okay. If you miss this court date, just like anybody else, there'll be a warrant for your arrest. Okay?
Yes, Your Honor.
I'm sure you want to go and get it resolved. And if you are released, it is likely that a condition, and I'll make it formal, but it's likely that a condition will be that you not have any contact with the alleged victim whose initials are AH. Do you understand that?
He has a restraining order, Your Honor.
Okay, but even if there was no restraining order, you would still not be allowed to have contact. May I ask you, please, do you have children with this person, child or children with this person?
One.
One. How old is the child?
One.
And who does the child primarily reside with?
Me.
Okay. All right. I'm not sure how the visitation with the child is going to take place, but you would be ordered not to have any contact with, I guess, Andre is the guy, which would mean not in person, not by phone, not by text or email, not by social media, not by anything on the internet, not by letters or notes. And if he contacts you because he misses you or he wants money or whatever, he wants to see the child, you're not to respond. You understand that?
Yes, Your Honor.
Okay. All right. There's going to be more to come, but we did the first half of it while I'm waiting for BCJ people. Okay, so I'll come back to you, and we'll have your attorney also involved, and we'll see what she has to say. But I just gave you the basic rights and the basic outlines. You're going to hear me talk to the men about the pretrial detention hearing. Apparently, you do not have to worry about that because there will not be a pretrial detention hearing for you, which is good because that hearing would determine whether or not you would stay in jail until your trial. You're not. So that's why it's real important to follow these conditions so that the prosecutor doesn't file a motion to revoke your release. You with me?
Yeah, sure.
Okay. All right. I'm gonna talk to the BCJ people and just stand by and we'll wrap things up with you in a minute. Okay.
Yeah, sure.
Okay. So don't go anywhere, but you'll be out of there soon. All right. BCJ, we're looking for 4 people. Can't hear you, BCJ. Does that lock me in their meeting?
Yeah, good morning,
Okay,
Your Honor.
now I can hear you. Hello, sir.
Yes, we have-
What's the story?
Yes, we have
What's
2
that?
right now. Sweat and Thomas are here right now, and the other 2 are closed custodies.
Oh, ouch.
They have to be
Okay.
brought up.
Can the other 2, so do we have to do Sweat and Thomas and then the other 2?
Yes, they're closed custodies. They're on their way up.
Can I wait for them?
Yeah, you can, or you can do these 2. Yes, it's up to you.
All right, we're gonna wait for them, but I'm gonna get started with their charges, okay?
Okay.
All right. All right. You're here, sir. Good morning. You're here for Kurz? Okay, what's your name?
Andrew Imperiale, Imperiale.
Okay, and you're the attorney for Mr. Kurz?
Yes, Your Honor.
And they let you in?
They did let me in, yes, Your Honor.
Pretty good.
But I should still come, so I did.
You did? Well, good. Happy to have you, and it'll be easier to have you here in person, so that's good. Prosecutor's appearing by video,
I thought so.
and I have to do first appearances for people that haven't had them yet. Your guy did have his.
At your convenience, Your Honor.
Okay, thank you very much, sir. All right. We're going to get started a little bit ahead here. Mr. Sweat, can you come up, sir? Antonio Sweat? Hi, Mr. Sweat. I want to just tell you what your charges are. We can go over that. Your case number is W2020-52-311. You have one charge, sir, and it is a charge from East Hampton Township on March 17, 2020. You are charged with simple assault in a domestic violence context. You understand that that is the charge, Mr. Sweat?
Yes, sir.
Okay. Now, sir, this is a disorderly persons charge. It will ultimately be heard in municipal court. It's not indictable. You would go to what is the East Hampton Municipal Court, but you know they have these courts in West Hampton, and your court date is on Monday, April 16th at 7:30. They start very early. Again, Monday, April 16th at 7:30. Do you know where the West Hampton court is, sir? Yeah, East Hampton doesn't have their own court anymore, so they folded it into West Hampton.
That's not the court that I went to before, well, the police station I went to before I got here, is it? Is that West or
Probably
East?
not. I think the police station you went to was East Hampton. The West Hampton court's
Okay.
on Rancocas Road. If you're leaving Mount Holly, it's on the way to Willingboro. It's before you cross over the turnpike in 295. It's on the
Okay.
left there. It's a brick building.
Okay.
You know where that
Well,
is?
once I get my-
There's like a
once I
school
get my
after
phone
that.
in-
There's
I
what's
can
that?
GPS it once I get
Yeah.
out of here. That's
Yeah,
no
you
problem.
you can't miss it. So you got to go to that court date, sir. Again, and they'll
And
write
you
it down
said
for you.
Okay.
It's going to be on a Monday. Why am I saying Monday? Okay, I'm totally messed up with the Monday part. It's on a Thursday, April 16th. Sorry about
Okay.
that. Thursday, 4/16 at 7:30, and that's in the West Hampton court. All right, so you got that, and you know that there's no pretrial intervention for you, no drug court, no grand jury, no jury trial. You'll hear me say that to some of the other guys, but it does not apply to you, Mr. Sweat. You understand that?
Yes, sir.
Okay. I have other things to tell you about your rights. I have other things to tell you about the pretrial detention hearing, but I'm going to wait until the other two guys come up so I can say it all at once if I can do that. And so I'll have you come up in a few minutes, okay, sir?
Yes, sir.
All right, thank you, Mr. Sweat. Mr. Thomas, are you the other person? Mr. Thomas, come on up. We have Fred Thomas here, W 2020-81-320. Mr. Thomas, you have 3 charges for Maple Shade. They're from March 16th, 2020. The 3 charges are terroristic threats. That's a third-degree offense. Possession of a weapon, a bat is the weapon they're talking about, and then unlawful possession of a weapon, which is the bat. You understand that those are the 3 charges, Mr. Thomas?
Yes, sir.
Okay. Same thing, sir. I'm going to have you, and these are indictable charges, so the things I'm going to tell everybody applies to you. I'll have you come back up, sir, once the other 2 guys get here, and I can tell everybody their first appearance rights all at the same time. Okay?
Okay, can I ask you this? Am I leaving, Your Honor, on this charge?
Well, that's part of what I'm going to tell you about, sir. I'm going to tell you about the pretrial detention hearing that's scheduled for you today, and the pretrial detention hearing will determine whether or not you are detained or you are released. Because, as you'll hear me say, the prosecutors filed a motion in each of the cases here for pretrial detention. The prosecutors are asking me to keep you and the other guys each individually in jail until your trial. So that's why we're going to have a hearing to see if that happens. So more to come on that. Okay.
All right, Judge. Thank you, Judge.
All right. Thank you, sir. Mr. Thomas, have a seat. We'll have you come up. Yeah, just have a seat. I'll come back to you.
All right.
All right. Since we have the prosecutor and public defender here and we're still waiting, can you enter your appearances, gentlemen?
Thank you. Good morning, Your Honor. This is Prosecutor Brandon Almeida from the state.
Good morning, Your Honor.
Thank you. Can you turn up your
defender's office?
Okay. Mr. Almeida, can you turn up your mic a little bit for us, please?
Let me see. Is this any better if I move it closer?
Yeah, that's better.
All right.
Okay. While we're talking, do you have Ms. Finizio's phone number?
Yes, Judge. 1 second. All right. 609-230-0374.
Let me repeat that back to you. 609-230-0374.
Correct.
Okay. Let's see if we can do that one now real quick while we're waiting for the other guys. Because this is a agreement to release on monitoring level. Who thought I'd be using all this technology? Started practicing with no fax machines, barely had electric typewriters. Hello, Miss Finizio, is that you?
Yes.
Hi, Judge Tarantino here. Good morning. And we have Miss Webb here. And we have Prosecutor Brandon Almeida here as well. Miss Webb has just had her rights explained to her. And I believe that this matter is resolved without the need for a hearing. Could you enter your appearance, please?
Yes. Good morning, Your Honor. Michelle Finizio on behalf of Devin Webb.
Okay. Miss Webb, can you hear your attorney?
Yes, Your Honor.
All right, excellent. Mr. Prosecutor, in this case, Ms. Webb has just had her first appearance. The prosecutor has filed a motion for pretrial release, but it's my understanding that after speaking with counsel that the motion is withdrawn. Mr. Prosecutor?
That's correct, Your Honor. After speaking with Ms. Finizio, the state moves to withdraw its motion for pretrial detention. As it's the state's understanding, Ms. Webb will consent to being placed on level 3+ monitoring involving home detention. And in addition to the standard conditions of release, the state would request no contact with the victim with the initials of AH.
All right. Ms. Finizio?
Yes, that's correct, Your Honor. That's
Okay.
the agreement that we came to.
All right. Is Ms. Webb employed? Is she working?
No, Your Honor.
Your Honor, can you ask Ms. Webb that? I don't
Sure.
have her files right in front of me, but I don't believe that she is.
Are you working?
Devin?
Are you working,
No,
Ms.
Your
Webb?
Honor.
Okay,
Your
that
Honor.
makes things a lot easier. All right, Ms. Webb, You are released on monitoring level 3+. What that means is you have to report to pretrial services every week, alternating in person, by phone, in person, by phone. So first week in person, second week by phone, third week in person. However, due to the current situation going on, they are going to have some alternatives for you, probably by phone, but at a certain point they're going to have you, they're going to try to have people report by video. So you have to talk to pretrial services, and it's a flexible situation, but just the thing is, don't blow it off. Make sure you stay in touch with pretrial services. The office is located on the first floor of the Burlington County Courthouse. And so that's where you go. Now, are you still living at 10 Mulshire Lane?
Yes, Your Honor.
Okay. That's where you stay 24/7. So, in other words, doesn't matter if it's a weekday, weekend, holiday, whatever, you're home at all times. May be a little frustrating, but it sure beats being in jail at all times. And you can be with your baby and just stay at home, like most people are doing these days anyway. But you're staying at home until the case is resolved. The case hopefully will be resolved sooner than later, because we talked about your April 16th court date. Wait a minute, what did we talk about?
May 6th.
May 6th court date, and hopefully you can resolve it on May 6th at 9 o'clock. If you miss that court date, a warrant will be issued for your arrest. If for some reason you're moving, if your family, it's a family home that you're at in Mulshire, correct? Okay, if for some reason you move, let pretrial services know what your new address is. I'd like for you to please give me your phone number.
When you're ready.
Okay, go ahead. What's your phone number?
609-836-4132.
Okay, very good. You are.
Honor,
Yes.
one question. Well, pretrial services will give her some sort of a condition to be able to go out just to get food for her family, correct?
No.
No. Okay.
No. Ma'am.
To make alternatives.
Yeah. Home detention is your home, except if you have to go to court on May 6th and maybe other court dates after that. And also, if you're going to pretrial services, which I don't think for the foreseeable future they're going to have you go over there in person. And when you do go to court or you go out, you're going directly to and from. You don't stop to buy something. You don't stop to get something to eat. You don't stop to go through the drive-in to get a cup of coffee or whatever. You are going directly there and back. If you need food in the house, you're going to have to rely on your family to help you with that. But again, it's very strict. Home detention is no exceptions, except for court or pretrial services. You understand that?
Yes, Your Honor. I have a special needs child, though. So how would that work?
Well, what does the special needs child have? What has to happen with that child, please?
He's just accident prone, and we spend a lot of time in the emergency room.
If you have to go for medical reasons, that you can do that too. I'd like to say have a family member take the child to the hospital, but I'm not gonna say that. Just go to and from the hospital if that's necessary, and hopefully that will not happen at all, or not happen often if it does. Ma'am.
There's a lot of family support, Your Honor.
Yeah, which is good. Okay, and I'm sure that's part of what the prosecutor took into account when he agreed to withdraw the motion. Ma'am, you are not to possess firearms, destructive devices, or dangerous weapons. You don't have a firearms purchaser ID card, do you?
No, sir. No, Your Honor.
Okay. Don't get. All right, good. Don't get any guns or anything else dangerous. And again, we're going to go back to no contact with AH, not in person, not by phone, no text, no email, no social media, no letters, no notes. And if he contacts you, you're not to return the communication. Maybe you can have family members talk to him, but you cannot talk to him. And I'm thinking about the baby. Be very careful about that. If there is a restraining order, you're to obey all restraining orders. But even if somehow the restraining order gets dismissed, you're ordered to not have contact with him. It's not. If you have contact when there's a restraining order, you're violating two things. You're going to get another charge for violating a restraining order, and you're going to be in violation of pretrial monitoring. If the restraining order is removed, you're still violating a pretrial monitoring condition if you have contact, okay?
Yes, Your Honor.
Okay, all right. I think that's everything. Do you have any questions, Ms. Webb?
No, Your Honor.
Okay. Ms. Finizio, anything more that we need to discuss?
No, Your Honor.
Okay. Mr. Prosecutor, anything more, sir?
Nothing further from the state, Your Honor. Thank you.
All right. Okay, good. So as we got through this, Ms. Webb, good luck. Please be careful out there, and wish all the best to you, okay?
Thank you.
All right, thank you. Thanks, Ms. Finizio. We're going to go off the record. I'll hang up. Take care.
Thank you, you too.
Okay. Bye-bye. All right, bye. Okay, we're done with ACJ. All right, that makes life less complicated. And I think the officer wants to talk to us in BCJ. Hello,
Yes,
sir.
we have-
Any news on
yes.
our other two guys?
Yes, Your Honor, we have Stephen Wagner here, the other one is to keep separate, so we have to do those separately, okay?
Ouch. Okay. All right, very good. We'll deal with Mr. Sweat, Mr. Thomas, and Mr. Wagner. You're saying Mr. McLean we'll deal with later?
Yes, Your Honor.
Okay. All right, very good. Thank you. Good morning, Mr. Sweat, Mr. Thomas, and Mr. Wagner. I've already told Mr. Sweat and Mr. Thomas what their charges are, and I will go over your charges with you, Mr. Wagner. Keep in mind, whatever you're charged with, you're presumed innocent unless you plead guilty or you're found guilty after trial beyond a reasonable doubt. Also, you have the right to remain silent. Anything you say will be used against you, so be careful what you say and who you say it to. You can talk to your attorney in confidence, but that's the only person. Speaking of attorney, you have the right to have an attorney represent you at every stage of the proceedings. You can hire an attorney, but if you can't afford one, you should apply immediately for the public defender. There's a form called a 5A form, 5A form. Fill that out. If you qualify for the public defender, somebody from the public defender's office will be assigned to your case. Talk to your attorney about two programs that might help you resolve your charges. One is pretrial intervention, and the other is drug court. Pretrial intervention and drug court are both programs that may assist you. They're separate programs. They require your attorney to apply online for those programs, but talk to your lawyer about that. If you don't have a lawyer yet, the pretrial detention hearing that's scheduled for you will be handled by the public defender, who automatically represents people for pretrial detention hearing. But after pretrial detention hearing, the public defender's office will not continue to represent you unless you apply and you are accepted. Okay, you have a right to a hearing as to probable cause. That's actually part of the detention hearing, so I'll come back to that in a minute and tell you about that.
Yes, sir.
Now, down the line, in the future, weeks or months from now, you have the right to have the prosecutor present your charges to a grand jury for possible indictment by the grand jury. You can always waive a grand jury, but you do have that right. And ultimately, at the end, you have the right to a jury trial. You may talk to your attorney and decide that you don't need a jury trial. And if you made that choice, you would have a trial by judge alone. Okay, those are basically your rights. Let me talk to you about the pretrial detention hearing. That's scheduled for today. I'm not sure if they're all going to take place, but they're scheduled for today. Here's what happens at the hearing. The prosecutor has filed a motion for your pretrial detention, meaning that the prosecutor is asking the court to order that you will stay in jail until your trial. So that's why we have to have a hearing to see if that happens or not. At the hearing, the prosecutor has to show probable cause for the offense. Probable cause is a low standard of proof. It's just a well-grounded suspicion that an offense occurred. It's not proof beyond a reasonable doubt because the probable cause hearing is not a trial. At trial, somebody has to be found guilty beyond a reasonable doubt. That's not what this is about. This is just probable cause. Again, a well-grounded suspicion or a reasonable suspicion that an offense occurred. The other part of the hearing is that the prosecutor has to show, by clear and convincing evidence, that there are no conditions of release for somebody that would ensure their appearance in court when required, or that they would not be a danger to those in the community, or that they would not obstruct the criminal justice process. So in other words, the prosecutor is arguing that there's no way that somebody could be released, even if there were conditions of release, because even if there were conditions and they were released, they would still either not show up in court, or they would be a danger to the public by continuing to commit offenses, or they would obstruct or attempt to obstruct the criminal justice process, or any one or more of those three things. If that can be shown, then the person is detained. Now, on the other hand, if you're released from the case, you should expect conditions of release. Let's go through what some of those conditions would be. Not to commit new offenses, to report on a regular basis to pretrial services, to notify pretrial services if your address or phone number changed, and to attend all court appearances. And your court appearances, your next court appearance, you guys all have the same date, or do you? No, you don't. Your court appearances are going to be different. Mr. Sweat, you're going to be in the West Hampton Municipal Court on Thursday, April 16th at 7:30, and I'll write that down for you. Mr. Thomas and Mr. Wagner, your court appearances are on Wednesday, May the 6th, here at the Burlington County Courthouse on the 7th floor for a pre-indictment conference. Mr. Thomas and Mr. Wagner, you have indictable charges, and those cases will be heard first at a pre-indictment conference, not a trial date, to see if you can resolve those charges. And you'll see Judge Morley at you'll see Judge Covert at 9 o'clock in courtroom 7A. And if you miss anybody misses any court dates, there'll be a warrant for their arrest, just like anybody who has court obligations. Okay. We will now talk to Mr. Stephen Wagner.
Yes, sir.
Oh, before, raise your hand. Anybody here not a U.S. citizen? Anybody here not a U.S. citizen? Okay, I assume everybody is a U.S. citizen. Anybody here a United States military veteran? Raise your hand if you're a U.S. military veteran. Okay, I'll assume nobody is that. And those questions are asked so that I can tell you additional things, but they don't apply. All right, I have Stephen Wagner here. I have two warrants complaints, W2020 75-320 and W2020 76-320. Mr. Wagner, I'm glad you're out of the hospital, and let's talk about what your charges are. You have on number 75, Maple Shade charge from March 15th, 2020, domestic violence, simple assault, that's a disorderly person defense. You have on 76, Maple Shade, March 15th, 2020, an indictable charge of resisting or eluding by threatening to kill the officers while refusing to comply with verbal commands after being verbally told that you were under arrest. So those are the two charges. You understand those charges, Mr. Wagner?
Yes, sir. May I say something first?
No, sir, don't say anything about your case. I don't want you to incriminate yourself.
Thank you, sir.
Sir, okay. Sir, do you have any questions about your rights in general? Don't tell me details about your case, gentlemen.
No, I do not, sir.
Okay, very good. I have the prosecutor and public defender here on video. I don't know if you can see them in your little squares on the screen.
Yeah, I see two people on the left and the right.
Okay, good. Gentlemen, can you wave a little bit and enter your appearances so they know who you are?
Good morning, Your Honor. Assistant
Who's that?
Prosecutor Brandon Almeida for the state.
Good morning, Your Honor. Anthony
Hello, sir.
Rizzo from the Public Defender's Office on behalf of the defendants.
All right,
Yeah.
thanks, guys. All right, Mr. Prosecutor, you filed a motion for pretrial detention for Mr. Wagner. He's had his rights. Are you ready to proceed, sir?
No, Your Honor. At this time, the state would request an adjournment until Tuesday for discovery-related issues.
Okay, Mr. Rizzo?
No objection, Your Honor.
All right, Mr. Wagner, your case is going to be heard on Tuesday. You're detained until then. Let me explain about this. The prosecutor is up to 3 business days to postpone these cases. Are you listening to me, Mr. Wagner? Prosecutor is up to 3 business days to postpone these cases. Defense is up to 5 days to postpone these cases. The prosecutor is using 2 of his 3 days. He's allowed to do that, no questions asked. But he has told me that he is not ready to proceed with your case because the police reports are not finalized. He needs to provide those police reports to defense counsel, so and in advance of the hearing. So he hasn't done that yet. He says he's going to do that by Tuesday. So we will come back with your case on Tuesday, March 24th at 9 o'clock. You understand that, Mr. Wagner?
Yes, so am I being released until then?
No,
Please.
sir, you're detained until then, and then.
Why am I being
as a-
detained?
Because once the prosecutor files a motion for someone's pretrial detention, they are detained until the hearing. Your first appearance in hearing is scheduled for today as normal. We just did that. We just did your first appearance. But then once it's scheduled for a hearing, which is today, the prosecutor is up to 3 days beyond today. These are business days, 3 days beyond today to postpone. So
May I speak to the
Monday,
prosecutor?
Tuesday are 2 business days. What's that, sir?
Mr. Prosecutor, can you hear me?
Oh, no, sir, you're not talking directly to the prosecutor. You're not doing that.
Oh,
Do
may
you have
I
any
speak
other
to him?
questions for me, sir?
No, why does the prosecutor not have his paperwork done? And why should I be held accountable for his
Sir, 2
problems?
things here. First of all, we're not going to debate. I'm happy to answer questions, and I'm very happy to inform people of what's going on. So I'll address what you just said. The police department prepares reports. They give the reports to the
Police department hit a
prosecutor.
schizophrenic with a fucking taser, so no, I gotta be held accountable.
Okay, we are done with our
'cause I go
proceedings
to
today,
cops 'cause
Mr.
I got
Wagner.
hit.
All right, would you take
Yes,
Mr.
sir.
Wagner away, please, officer? Officer, do you hear me? Take him away. He's now disrupting the court, and he's not doing himself any service by an outburst of emotions when he's surrounded by officers who are in uniform. That is a shame. Okay, we will have Mr. Wagner then on Tuesday, postponed by the state.
We
right,
also have
we now
Ronald
would
McLean
actually-
up here.
You have Mr. McLean. Okay, I'm going to come to Mr. McLean in a minute. Let me just deal with Mr. Sweat and Mr. Thomas. Mr. Sweat, can you come back up, sir? W2020 52-311. Mr. Sweat, we went over your charges already.
Yes,
and now
sir.
you heard your rights. Do you have any questions about your rights, sir?
No, sir.
Okay, all right, very good, Mr. Sweat. Mr. Prosecutor, are we ready on this case today?
Yes, Your Honor, the state ready to proceed.
All right, Mr. Rizzo, are you ready, sir?
Yes, sir.
All right, very good. So, Mr. Sweat, your case will take place today. Bear with us. I've got other cases besides the guys you see. I've got like 4 other cases, and then I got Judge Haynes coming up to do a 5th case. So just know we'll get to you at some point today, okay?
Will I be released today for Trenton?
Well, that's what the hearing's about. The hearing's about, will you be released with conditions or will you be detained? So we'll find out when we have the hearing, sir. I have no idea.
Understand.
All right, so see you in a little while, sir. Thanks. Mr. Fred Thomas, W2020 81-320. Mr. Thomas, we did already go over your charges. Sir, do you have any questions about your rights?
I don't even know. I don't even know what my race is.
Well, I just told you, right to remain silent.
Oh, yeah, I'm good. Yeah.
Those
No,
things.
thank you. Yeah, I got it.
Okay, all right, good. Good. Mr. Prosecutor, are we ready on the Thomas case today?
Yes, Your Honor, the state's ready to proceed.
All right, Mr. Rizzo, are you ready to proceed?
Yes, I am, Your Honor.
All right, very good, guys. So, Mr. Thomas, we will have you come up at some point today, or actually come back into the assembly room, and we'll have your hearing today. So thanks, Mr. Thomas. So, Officer, Mr. Sweat and Mr. Thomas can go to whatever other room you have them in, and I will deal with the McLean case now. And Mr. Ronald McLean, would you come up, sir?
Good morning.
Now, Mr. McLean, how are you for standing? Are you okay to stand?
Yes, I'm okay.
Okay, if you get tired, have him pull up a chair for you, but if you can stand, that's probably better. This is the Ronald McLean case, W2021-42-324. Sir, this is from Mount Holly Township. These are charges from March 17th, 2020. And sir, in Mount Holly, you have two charges, second-degree burglary and also second-degree robbery. You understand those are the 2 charges, Mr. McLean?
I understand.
Okay.
I
Sir,
heard that you said
you are
have
presumed
second-degree
innocent?
burglary and second-degree robbery. And
Those are the
from my
charges.
understanding, And from my understanding about burglary and robbery, first you would have to have some type of forced injury or something like that, which I know it didn't, never took place. It would be
Okay, now
more
stop
of
right
a-
there. Stop right there, sir. Stop right there. Couple things. First of all, talk to your attorney about the elements of the offense. Keep in mind, and you're on the right track here. You're really on the right track because you're presumed innocent unless you plead guilty or you're found guilty, and you have to be found guilty beyond a reasonable doubt. So talk to your lawyer about that. Sir, you have the right to remain silent. Anything you say can be used against you, so be careful what you say to anybody, except you can talk to your lawyer in confidence. You have the right to have an attorney represent you. You can hire an attorney, or you can apply for the public defender. The public defender will represent you in the detention hearing, but after that, you have to apply. It's a 5A form. You have to fill out a 5A form, and if you qualify, the public defender's office will represent you for the whole case. Talk to your lawyer about two programs that might help you: pretrial intervention and drug court. Those are programs that might assist you in resolving your case. In any event, in your case, you have the right to, drug court and pretrial intervention require your lawyer to apply online for those programs. In any event, sir, you have the right to a hearing as to probable cause. You also have a right to have the prosecutor present your case to a grand jury for possible indictment by the grand jury. You can always waive an indictment, but you have that right. And ultimately, you have the right to a jury trial. You can waive a jury trial, and if you made that choice, you'd be tried by a judge alone. And those are basically your rights. Now, today, sir, there is a detention hearing that has been scheduled. What has happened is that the prosecutor has made a motion to detain you, keep you in jail until your trial. So we have to have a hearing to see if that happens. At the hearing, there are two things. One is probable cause. The prosecutor has to show probable cause, which is only a well-grounded suspicion that an offense occurred, not proof beyond a reasonable doubt, which is the trial standard, but just a reasonable suspicion or a well-grounded suspicion that an offense occurred. The other thing that happens at the pretrial detention hearing is that the prosecutor has to show by clear and convincing evidence that there are no amount of conditions of release that would ensure that the person would appear in court, that the person would not be a danger to others in the community, or that the person would not obstruct or attempt to obstruct the criminal justice process. So in other words, the prosecutor would be arguing that there's no way that this person can be released, because even if they were released with conditions, they would still be a danger to the community, they would still not show up in court, or they would obstruct or attempt to obstruct the criminal justice process, or a combination of one or more of those three things. That can be shown the person is detained. Now, on the other hand, if you're released from the case, you should expect conditions of release. Those conditions would include things like not to commit any new offenses, reporting to pretrial services on a regular basis, notifying pretrial services of your address or phone number change, and attending court appearances. Mr. McLean, your next court date is on May 6th. We'll talk about that more later. May 6th is not a trial date. That is a pre-indictment conference date here at the Burlington County Courthouse on the 7th floor, courtroom 7A. All right. Do you have any questions about your rights, sir? And please don't talk to me about the details or the facts of your case. Just in general, do you have any questions about your rights?
Okay, yes, I can agree by the conditions for the courts to the pre-trial hearing and stuff like that. Therefore, being out on bail or something like that. Yeah, I've been through that before, and I was very, very good candidate for that. And
right
now, I still have a probation officer.
Sir, first of all, that's not a question, but that's something that your lawyer will argue. Let me just point out to you that we really don't have bail anymore since January 1st, 2017, except when people miss court, then there's a warrant and there's bail set because they miss court. But when we're talking about pretrial release, almost never is there bail imposed, but instead if someone is released pretrial, they're imposed with conditions. Now, you're starting to tell me all the reasons why you believe that you would be a good candidate and can be properly maintained in the community. And that is absolutely very relevant, and that's something your lawyer is going to have to argue for you. So that when you talk to your lawyer before the hearing, you want to go over those things with your attorney. But we're not going to go over them now because your lawyer is going to present them when we have the hearing. All right. Mr. Prosecutor, are you ready on the McLean case?
Yes, Your Honor. The state's ready to proceed.
All right, Mr. Rizzo, are you ready, sir?
Yes, I am, Your Honor.
All right, we will have the McLean case this morning then, gentlemen. And we will come back to Mr. McLean in a little bit. All right, thank you. Now, we're going to have Mr. McLean can go to the waiting, I'm going to call it the waiting room. If the officer, if there's a better room to call it, let me know, and I'll call it by the right name.
You're correct, we can see. Hey, Your Honor, when you start your detention hearings, could we see Mr. McLean first, because he's a close custody?
Yes. You guys ready on the McLean case?
It's ready, Your Honor.
You guys ready on McLean?
Yes, Your Honor.
Okay. Now, for purposes, so let's have Mr. McLean come in. And we'll get his case. For purposes of the hearing, I have some of the documents, Mr. Prosecutor, and I don't. If you have other documents, I guess that we're being trailblazers here. But I have the PSA, I have the complaint warrant with probable cause and PLEIR, and I do have the CCH. If you have other documents, I don't have them. I guess we'll have to figure out how I'm going to get them.
So, Judge,
but hopefully we can muddle through.
Judge, for every case that the state's ready to argue today, I actually scanned the exhibits and emailed them to Janice, who I believe she just said she forwarded them to both you and Connie. So I'm hoping you have an electronic copy in your emails of everything the state is going to move to admit. And I think for every case, just the PSA complaints and the CCH.
Okay, because I need to have them printed out if we're going to be exhibits. But okay, let us see how we do. We'll take it one step at a time. And certainly, Mr. Almeida, you did everything you're supposed to do. You got it. Oh, and we do have them. So, all right, good. Thank you. Okay. We'll now address the Ronald McLean case. Mr. McLean's warrant number is W2020-142-0324. I have some documents. Okay.
Is this very loud?
No. Just trying to save paper. May I have Mr. McLean just had his first appearance. The state has filed a motion for his pretrial detention, and we have Mr. McLean here on the screen. May I have your appearances for this case, Mr. Prosecutor and Mr. Public Defender.
Thank you. Assistant Prosecutor Brandon Almeida for the state.
Anthony Rizzo appearing on behalf of Mr. McLean.
Thank you, gentlemen. Mr. Almeida, you ready, sir?
Yes, Your Honor. Thank you. To begin, Your Honor, the state would move to admit what's been marked as exhibits S1 through S4, with S1 being the public safety assessment, S2 warrant 2020-142-0324, S3 the affidavit of probable cause for same, and S4 the defendant's criminal history.
Mr. Rizzo, any objection to S1, 2, 3, or 4?
Your Honor, I have copies of S1, 2, and 3. I don't have a copy of S4, so I would have to object to that.
Tony, I CC'd you on the, or I copied you on the email that I was referring to earlier. If you check your inbox, there should be an email with this attached as an exhibit.
What time did it come in?
I sent it at 9:13.
9:15. I got. All right, hold it.
It's all in one document. Attached just
I
as.
see it. Yeah.
All right, gentlemen, S1 through 4 are admitted in evidence.
I do have that.
And what's that? Mr. Rizzo, any objections? S1 through 4?
No, Your Honor.
You said no? Okay. Okay. All right, I may need more time to look at the exhibits, but I'm looking at, I'm looking to try to get moving here. So, Mr. Prosecutor, anything more that you have, sir?
Yes, Your Honor, thank you. First, with respect to probable cause, the state relies on the affidavit of probable cause admitted as S3. With respect to detention, the state first notes the public safety assessment scores. Mr. McLean scores a 4 and a 6, and there is a new violent criminal activity flag. At the time of this offense, the defendant was also on probation. Taking this into account, the recommendation of pretrial services is no release. In the current matter, the defendant has 2 total charges, second-degree burglary and second-degree robbery. The charges stem from an incident. Police were called and respond and see the victim, a juvenile, and the defendant fighting on the sidewalk. After separating them, the victim explains he was leaving the bathroom in the residence and he saw the defendant, a stranger, going through items on a bed. The victim confronted him, asking, "Who are you?" The defendant proceeds to punch him several times and they get into a physical altercation. And it's inferred that the defendant had no permission to be in the residence and was attempting to steal items. Looking at the personal characteristics of Mr. McLean, he is a convicted murderer who continues to offend ever since his release from jail. At the time of this offense, he had 1 pending charge, a burglary out of Somerset. It looks like from the Primus Gavel number, this case is from 1982, so I'm not sure how much weight, if any, to give that. But looking at his prior convictions, he has 1 prior DP conviction for CDS. However, looking at his indictable convictions, he has a total of 10, most notably for murder and 3 robberies in 1990, which he ultimately received a 30-year New Jersey State Prison sentence. And ever since his release from jail, we see a pattern of CDS abuse recently. We have an indictable CDS conviction in 2016, a DP CDS conviction in 2017, and most recently, as soon as January 24th of 2020, we have another indictable CDS conviction, which is what placed him on probation. So not only do we have someone who just got a conviction recently, he was also just placed on probation prior to the incident offense. With respect to his risk of...
What date, sir, what date was he placed on probation?
The conviction showing as January 24th, 2020, Judge.
Okay, thank you, sir. Go ahead.
With respect to his risk of failing to appear, he scores a 4 out of 6 on his PSA. I note that he only has 1 prior failure to appear outside of 2 years. So I'm not sure whether the failure to appear score accurately reflects his history. However, the state submits there's higher risks of obstruction and danger to the community. First, with respect to obstruction, the state submits there's a moderate risk. On the CCH S4, there's an alias listed as Popo Blunt, and there are also a total of 6 social security numbers listed. And so the state submits based on that, there's a moderate risk of obstruction. However, the state's focus here is the danger to the community. The state submits there's a high risk. First, he scores a 6 out of 6, and there's a new violent criminal activity flag. This is someone who is a convicted murderer who picked up a unabated CDS abuse issue since his release from jail, and now he just committed a violent home invasion. This is someone who's demonstrated he's not amenable to release. As referenced earlier, this is someone who's just put on probation less than 2 months ago. And taking his recent pattern of CDS convictions into account, the state submits it's reasonable to infer that he was breaking into this residence trying to steal items likely to fuel his CDS habit. This is someone who's clearly not deterred by his prior contact in the criminal justice system. He has a total of 10 prior indictable convictions, 9 arrests. He served a 30-year prison sentence for murder and was just put on probation. And despite of all of that, he clearly continues to offend, as demonstrated by his recent conviction in January, and now being put on probation, and now a violent home invasion. Judge, for these reasons, the state's asking that you follow the recommendation of pretrial services and find that there's no condition or combination of conditions that will assure his appearance in court, that will protect the community, or will prevent him from obstructing the justice process. And with that, the state submits.
Mr. Almeida, how old was the victim?
16 years old, Your Honor.
And was not known to the defendant?
I don't know, Your Honor, yeah, the victim reported that this person was a stranger.
Thank you. Mr. Rizzo.
Thank you, Your Honor. Your Honor, in reviewing the probable cause statement, this is a rather unique kind of situation. The victim came out of the bathroom, found the defendant in his residence. I believe it was his stepfather's residence. And when he asked what the victim was, what the defendant was doing, the defendant gave a strange or odd answer by saying he's looking for something. Apparently, the defendant was under some type of influence of either a mental aberration or of perhaps he was under drugs. But he's given an indication that he wants to get treated over at Oaks Integrated Care. So what we would ask, Your Honor, given all the factors the court has to consider, is that he be discharged directly to Oaks and he be monitored under level 3.
All right, thank you. All right, guys, bear with me here because there's more things I have to look at and write, but I appreciate, although, Mr. Prosecutor, is there anything that you wanted to respond to what the public defender said?
Just briefly, Your Honor, if this defendant committed this offense under the influence of CDS, that furthers the state's position, Your Honor. It further demonstrates that this is someone with an unabated CDS abuse issue, and the state submits that it's not appropriate to give him a chance to go to a program such as Twin Oaks, as referenced by the defense, as he already has a chance on probation, and he committed this offense while on probation. So the state submits that's not appropriate here.
Any final words, Mr. Rizzo?
No, Your Honor, thank you.
All right, thank you. Guys, just bear with me a couple minutes here. All right, thank you, gentlemen. This is the pretrial detention motion for Mr. Ronald McLean. The state has filed a motion for his pretrial detention, and we've had the hearing. First of all, the court does find that the state has established probable cause that the eligible defendant committed this offense. That's based on the probable cause affidavit in Exhibit S3, which includes the preliminary law enforcement incident report. It's brief, but it is descriptive and does indicate an offense in the court. Two offenses. The court does have a well-grounded suspicion that these offenses were committed. We know that probable cause calls for far less evidence than is needed to convict at trial. We're not trying the case. It's not proof beyond reasonable doubt. It's just well-grounded suspicion, and the court does find that. The court also finds by clear and convincing evidence that there is no amount of monetary bail, non-monetary conditions, or combination of bail and conditions that would reasonably assure this defendant's appearance in court when required, and/or the protection of the safety of any other person or the community. That's the main concern, and/or the defendant would not obstruct or attempt to obstruct the criminal justice process. The court finds the state has met its burden of clear and convincing evidence because after considering all the evidence here, the evidence favoring pretrial detention is so clear, direct, and weighted and convincing as to enable the court to come to a clear conviction without hesitancy as to the truth of the matters asserted. And there are many reasons for that, including the nature and circumstances of the offense charged, burglary, robbery, both second degree. They're serious, facing lengthy jail exposure because of those offenses. The particular circumstances are that this was essentially a home invasion. The victim was only 16 years old and was a stranger to the defendant, and victim was injured. The court also considers the weight of the evidence against the defendant, considering the admissibility of any evidence sought to be excluded. That includes the personal observation of the law enforcement officers who investigated. It also includes statements of witnesses, including the victim, and it also includes statements of the defendant to police and victim. And there's also physical evidence, including the signs of injury to the victim and the stolen property that the police recovered. The history and characteristics of this defendant are very concerning. His criminal history starts at age 18. He has 18 prior arrests, and he has 2 parole violations. His criminal history is reflected in the public safety assessment, and he does have a record concerning appearances at court proceedings, as reflected in the public safety assessment. And also, there's a current outstanding warrant in Trenton for this defendant from a 2019 case. Very significant is at the time of the offense, he's on probation for a recent offense. CAPS ID number is M0088460, and that's only since January 24th, 2020. That shows he is not amenable to pretrial monitoring. He also appears to be transient as far as his living situation is. The court's main concern is the nature and seriousness of the danger to any other person or the community that would be posed by his release. He's absolutely a danger to harm others in the community, including juveniles. Court, to a lesser extent, but is still concerned with the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process that would be posed by his release. There is a potential for witness intimidation of the victim and the victim's family, and also his prior use of alias and 6 different Social Security numbers is also concerned that he would try to conceal his identity and not be accountable to the criminal justice system. The release recommendations of the pretrial services using a public safety risk assessment is that release is not recommended. The public safety assessment scores are 6 and 4, and there is a new violent criminal activity flag. As he stands before the court, therefore, this defendant has outstanding warrants in Trenton. He had just got on probation less than 2 months ago. He has prior disorderly drug convictions, disorderly person drug conviction in 2017. He has 10 indictable convictions, including 4 for larceny or robbery. 3 of those are robbery, and that's what he's charged here. 2 drug-related and that are recent, and he has a murder conviction in 1990. And for that murder conviction, as we know, he got a 30-year jail sentence for murder. But here we are with recent offenses and with now another serious offense. So, to sum it up, the court is primarily concerned for danger to the public because ABC. A, defendant not detained from serious having serious convictions, lengthy prison sentences, or recent probation. B, defendant seems to have a combination of mental health problems and unabated substance abuse issues, bad combination. And the court is not going to release him to a program because the court is not satisfied he would comply with the program. And C, he has an enhanced level of dangerousness due to the fact that the victim was a juvenile and a stranger. And that means that everybody is at risk. And so that's a concern. The court therefore finds the state has more than met its burden, will order pretrial detention of this defendant. We have a 9 o'clock pre-indictment date on May 6, 2020. The court will direct the defendant be afforded reasonable opportunity for private consultation with counsel. Sir, you have a right to appeal this order within 7 days, return to Court Rule 2:9-13. Good luck to you, sir. Thank you, Mr. Prosecutor and Mr. Public Defender. All right, so we're finished with the McLean hearing. We want to do the Terrell hearing next.
Okay, we'll bring it right in, sir.
All right, and Judge Haynes will come in for that. Is he coming then? Did Kathy come check?
Yeah, I told her to come on in.
Okay.
Oh, I hope this was, I was gonna pass it, but then we'll.
Yes, yeah, yeah. Yeah, so, thanks.
I said, are we supposed to? And she said, yes, but they would be here if they could, the public. All right. I am so far to see my pants, nothing was prepped. No data entry was done. Scrambling.
Stand right there. Who you?
Good evening, sir.
Good morning. Are you Mr. Ronald Terrell?
Yes, sir.
Hello, sir. Why don't you have a seat, because you're going to wait for a couple minutes. Judge Haynes has to come and take this seat. I'm still writing stuff. Judge Haynes is on his way down, and we have to get Mr. Spracco on the phone. Then I'll clear out of here, sir. I'll have nothing to do with the hearing, but I just want you to know what's going on, okay?
I just want to say thanks for your appreciation, Tarantino.
Thank you, sir.
Thank you.
Mr. Rizzo, there is private counsel on this one.
Yes.
Hopefully it won't take that long.
Is it all right if I step out of the office for a moment?
Yeah, no problem.
Thank you, Your Honor.
Mr. Imperiali, is your case resolved or is it a hearing?
Your Honor, I do believe it's a hearing. I'm going to be still there probable cause, so I know it'll speed up a little bit, but I think it's a hearing.
Judge, what case is he here on?
Mr. Imperiali is here, and he's here for the Kurz case, K-U-R-Z.
Judge, is there any way we can address that now? The state's actually going to request an adjournment Tuesday on that case.
Okay, let's address it once you come up to council table. We're still on the record. This is the Thomas Kurz case, W 2020-43-316. This had been postponed from Wednesday, March 18th, by the state. And Mr. Brandon Almeida appears as on behalf of the state. Can you enter your appearance, sir?
Your Honor, thank you. Andrew Imperiali on behalf of Thomas Kurz.
Thank you. Mr. Prosecutor?
Thank you, Your Honor. The state is not ready to proceed in this case, Judge, for the same reasons as previously. The state will request an adjournment for discovery-related issues.
Mr. Imperiali?
Your Honor, unfortunately, I cannot object. This was scheduled for Wednesday, so that would be 2 days. I'm assuming that it would have to come back on Monday.
And actually, we don't do these on Monday. We have to go the next day that we do it, which is on Tuesday.
Your Honor, unfortunately, I can't object because the state does have that right.
All right. So the case is postponed. Do you waive his appearance, Mr.
Your Honor,
Kurz?
I do waive his
Okay.
appearance.
I'm sure you'll talk to him.
Yes, I will explain to him what the situation is.
So this is going to come back on March 24th. We need to make it happen on Tuesday, as you are well aware, Mr. Almeida.
Yeah,
and I'm sure that it will. I don't have any concerns. I'm sure that it will. All right, thank you, guys. That's good to get this rather than having you wait another.
Thank you. Your Honor, I'll be in touch with the state to see if it can be resolved prior to.
Okay. And you're welcome to come in person if you want to do it by, I think person is better, but
I think so
you got a
too.
video?
I'll make the drive, Your Honor. No
Okay,
problem.
all
Thank
right,
you.
good,
Have a
thanks.
Good afternoon.
We're off the record. Double check before and make sure they're gonna let people in, because they're talking about even us being remote.
I understand.
So I just don't, I don't know where you're driving from, I just don't want you to waste.
Philadelphia, so I make sure
Oh,
I check
yeah.
it. Yes. Thank you.
Judge, Mr. Sparko said he's waiting to be let in. Is that on here? How do we let
Probably.
him- How do we let him in?
Now they do it downstairs. They control it.
Who downstairs? Like Ben
Somebody down on the third floor.
on the third floor?
Can you let pretrial services, with that in mind, can you let pretrial services know to let him in, quote unquote? What a mess. Okay. And is Judge Haynes going to join? That's McLean.
I had emailed him to say we're ready to roll, so he said he's waiting to let in, so I just emailed him, said I emailed quote unquote the gatekeeper.
Okay. Okay. So, we don't need to print it out unless it's, stuff I don't have.
Yeah, the only thing is like that stuff came to me as one document.
Ah, yeah.
So,
Okay.
which I mean is better, but
Okay.
if I know what it is before, what you need beforehand, I can try to print just those pages.
Okay,
I was just running on the fly this morning. So
yes, okay.
I was trying to coordinate it and everything. Hi, Judge.
Hello, Judge Haynes, come on in, sir.
Figure out your own way how to get that.
Did I not instruct you that he was to bring coffee?
He doesn't do coffee.
But I do.
Next time.
Okay, you have the file, right? Okay, wait a minute, Kathy,
Kathy!
you have the file? You have the file?
Yeah.
You do?
Need
Okay.
her?
No, I don't need her now. Okay,
I got,
Okay.
the PSA,
yeah,
somebody sent some exhibits.
You got, so you got
Okay.
everything.
you have everything.
Yeah.
Okay, all right, I will clear out of here.
Are you ready?
We're looking for Mr. Spracco.
Spracco's here.
Okay.
Okay, good, okay,
All right.
all right, I'll,
You went out that way? All right.
go down this way.
Nice courtroom.
Yeah, it's newer.
Yeah.
I like it. I'll put my seat up for you, sir.
There you go.
Connie, let me know, okay?
I will.
All right.
Whenever you're ready, I will.
Okay, let me just get organized here.
2 complaints for detention and there's 1 VOM and motion to revoke.
Judge, are we off the record right now?
Yes.
Good morning, by the way.
I'm not on the record yet.
All right.
Not on the record yet.
Mr. Spracco, do you have the discovery in this case?
Yeah, I was able to download that off of the portal.
Okay, great.
Thanks, Brandon.
Figure out this in here. All right, ready? Okay, everybody ready?
Ready, Judge.
All right, these are the matters of State versus Ronald Terrell, appearances, police counsel.
Good morning, Your Honor. Assistant Prosecutor Brandon Almeida for the state.
Good morning, Your Honor. Richard Sparacco on behalf of Ronald Terrell.
All right, good morning, counsel. Good morning, Mr. Terrell. We are here for a motion to revoke release, I understand, as well as a detention hearing. Is there anything more that we're here for?
Not that I am aware of, Your Honor.
And not that I am aware of either, Judge.
Okay. How did council want to proceed? I'll start with Mr. Almeida.
Judge, I would ask that we do the motion for detention first. Pending the result of that, it would make the motion to revoke moot, depending on the result.
Okay. All right. Any objection to that, Mr. Sparaco?
No, Judge. I think that they are somewhat interrelated. I was prepared to argue both at the same time, but I'll do it that way.
All right. Very good. Thank you. All right, then, if you're ready to proceed, Mr. Almeida, you can proceed.
Thank you, Your Honor. To begin, Your Honor, the state would move to admit into evidence the standard exhibits for detention, the PSA complaints, and CCH. Before formally moving to do that, does the court have a copy of those before you?
I have 2 complaint warrants. I have a PSA with attachments, of course.
Okay.
And I have a couple exhibits that were just presented to me by staff, Exhibit D1 and D2. I don't know who they're from, but.
Those are mine, Judge. If we get to the violation of the pretrial release, those are germane to that particular motion. They would not be germane to the present detention hearing.
Okay, so thank you, Mr. Sparaco. Mr. Almeida, do you have S1, S2? Could you list, itemize those, please?
Yeah, sure. The state moves for S1, the public safety assessment. S2, complaint warrant 2020-265-0330. S3, the affidavit of probable cause to that complaint. S4, complaint warrant 2020-272-0330. S5, the affidavit of probable cause for that complaint. And S6, the defendant's criminal history.
Offering them in evidence?
Yes, Your Honor.
Any objection?
No, Your Honor.
All right, S1 through S6 are in evidence as identified. All right, then I'll hear from you, Mr. Almeida.
Thank you, Your Honor. First, with respect to probable cause, the state relies on the 2 respective affidavits of probable cause admitted into evidence, S3 and S5. With respect to detention, the state first notes the public safety assessment scores. The defendant scores a 4 and a 5. Now, the recommendation of pretrial services is release on weekly reporting, which of course is level 3 monitoring. However, Judge, the state takes issue with that recommendation mainly because at the time of the 2 instant offenses before the court, the defendant was already on level 3 monitoring. And for reasons the state will get into further in a moment, the state submits that releasing him back on the same level of monitoring is certainly not appropriate here. There are a total of 8 charges before the court for consideration, 4 from March 10th, 2020, and 4 from March 12th, 2020. Both sets of charges charge possession with intent to distribute CDS, possession of CDS, and possession of CDS paraphernalia. First, the charges from March 10th stem from a motor vehicle stop. The defendant was the sole occupant of a vehicle. Police ultimately obtained a search warrant for that vehicle and found 47 folds of heroin and also a bag of methamphetamine. Then, just 2 days later, on March 12th, a confidential informant advises police that the defendant was at a third party's residence hanging out in the rear shed. The officer shows up to that residence with the active arrest warrant for the defendant from the previous day, from the March 10th stop. After the search warrant, they got an arrest warrant for the defendant. So on the 12th, when they went to the shed looking for the defendant, they encountered him in the shed. And when they encountered him, the defendant had his hand in a black case. And upon arresting the defendant, police seized that black case and found 192 wax folds of heroin and methamphetamines inside of that bag. So just 2 days apart, we have 2 separate sets of possession with intent to distribute based on the quantity of heroin found. Next, looking at the personal characteristics of this defendant, Judge, this is someone who recently picked up an unabated CDS abuse issue clearly demonstrated by his conduct. At the time of the current offenses, he had 2 pending charges, both of which were incredibly serious. 1 count of second-degree witness tampering and 1 count of second-degree conspiracy to commit witness tampering pending at the time of these offenses. And those charges are what put him on PML level 3, Judge. Looking at his prior history, he has 1 prior conviction for a disorderly person's offense of obstruction and 2 prior indictable convictions for third-degree theft and third-degree eluding. So looking at the risk factors for detention here, first, the state submits there is a moderate risk of failing to appear. This is based on his PSA score of 4 out of 6 for failure to appear, as well as the fact that this defendant has 4 prior failures to appear. Next, the state submits that there is a high risk of obstructing the criminal justice process, most notably because of the 2 pending charges the state referenced earlier. This defendant has 2 second-degree witness tampering charges pending. The state would submit that based on those 2 charges alone, there's a high risk of obstruction, but there's additional conduct, Judge. First, this defendant has a third-degree resisting arrest / eluding conviction, as well as a prior disorderly person's a conviction for obstruction. So there's clearly repeated obstruction-related conduct by this defendant. Additionally, Judge, looking at this defendant's CCH, there are 3 social security numbers listed on the CCH, which the state submits as further evidence of his risk of obstruction. The fact that there's 3 different social security numbers shows that this defendant has taken steps and will take steps to avoid detection from police. Last, the state submits there is a high risk of danger to the community by this defendant. This is someone who's shown he's not amenable to pretrial release. This is someone, Judge, he's put on PML level 3 for the witness tampering charges, and then picks up 2 separate sets of indictable charges just 2 days apart. And of course, he's already on the highest level of monitoring. He's on level 3, and there is no level 4. And he violated his pretrial condition or pretrial release conditions in multiple ways. The most obvious being not committing offenses while on release. Not only did he commit offenses, he committed multiple offenses just 2 days apart. But another condition of pretrial release is that you not use any controlled dangerous substances. And of course, both of these offenses involved CDS. So this is someone who had his chance on the highest level of monitoring and clearly failed it in several ways. This is someone, Judge, a person committed to complying with pretrial monitoring. If arrested while on pretrial monitoring for CDS, you would think they would take appropriate steps to solve the issue, such as going to a rehab service. Instead, this is someone who did the exact opposite, who just 2 days later engaged in the same conduct. This is someone who's also demonstrated he's not deterred by his prior conduct or contact with the criminal justice system. Looking at his CCH, he has a total of 13 arrests in his lifetime, 2 indictable convictions, 2 DP convictions, 2 serious second-degree charges pending, and on the highest level of pretrial monitoring, and yet he continues to offend over and over again. And Judge, again, there's no level 4. He's already on the highest level of monitoring, so the state submits there's nothing left for this court to do. There is no alternative except detaining this defendant. And for these reasons, Judge, the state submits and asks that you detain Mr. Tyrell.
Very good. Thank you, Mr. Almeida. Mr. Sparaco?
Thank you, Your Honor. And as I indicated before, you know, these detention motions and the violation are somewhat related because Mr. Almeida does bring up the current present charges of tampering, which I'm going to get to in a few minutes. First, Judge, Mr. Tyrell is charged with nonviolent offenses. Clearly, there's a substance abuse component to the new cases, which we intend to address at a date sooner than later because of Mr. Tyrell's substance issues. For now, it's important to note, and I'm going to give you 3 factors that call for the denial of the state's motion for detention. First, Mr. Almeida paints a picture of my client being arrested, charged, and then arrested again 2 days later. That's not what happened here. There was no intervening arrest between W-2020-265 and W-2020-272 on, I think it was a March 9th or March 9th. My client was stopped in the woods near his vehicle. He was allowed to leave because he had some abdominal issues that he needed to take care of. There was no arrest at that point in time. He left the scene at that time. The police brought in the drug sniffing dogs. They got a search warrant from Judge Tarantino. The truck was searched. They found the drugs, and charges were lodged at that time, but he was not arrested. It wasn't until 2 days later that Mr. Tyrell was charged, was arrested in a shed of an acquaintance of his. So consequently, this is more of one ongoing offense between March 9th and March 12th, and it should be treated accordingly rather than, which would be more serious, in my opinion, and would support the state's position if Mr. Tyrell was charged, arrested, released, and then arrested again. Clearly, that would be an aggravating factor, but that's not what we have here. Number two, Judge, as for my client's prior record, there are third-degree convictions, and while I don't have the details surrounding those convictions, they were third degree, and they date back 17 to 19 years ago, to between the years of 2000 and 2003, when Mr. Tyrell was at the immature ages of from 18 to 20 years of age. Currently, he has attended every court appearance on his current charges, on his current indictment, since his release by Judge Cook. Or I think it was actually Your Honor had released him at that point in time, Judge. And he has been to court every time, on time, even early, as I request my clients to meet me there at 8:45 before the start of court. Number three, pretrial services recommends release with conditions, weekly reporting on the current charges. Now, normally that would be, in my opinion, an appropriate recommendation, but for this motion based upon the violation of pretrial release. So I would like to address that. Mr. Tyrell was placed on pretrial release at the time of those charges, and I believe that was about 7 months ago in August. I thought that was monthly reporting, but Mr. Almeida's indicated differently, and I'm not sure about that. So I'll defer to Mr. Almeida's information. But I do note pretrial services with regard to the violation of release, of pretrial release, Tiffany Ogilvy's report indicates that with regard to the 7 months that Mr. Tyrell has been on pretrial release, that, quote, to this officer's knowledge, the defendant has appeared for all scheduled court proceedings. And, quote, to this officer's knowledge, he has avoided all contact with the alleged victim of the offense, meaning the tampering charge. And, quote, to this officer's knowledge, he has reported to pretrial services as ordered by the court. Therefore, Officer Ogilvy's, quote, recommendation to the court that the defendant be released on PML 3+ with home detention and no electronic monitoring. So, Your Honor, the defendant would submit that Ms. Ogilvy's recommendation should be followed by the court as being reasonable in light of Mr. Tyrell's otherwise compliance with his pretrial release, appearances in court, and restraint from any contact with the victim. And one more further important factor, and the state's, in my opinion, should be the real position on the current tampering charge, although Mr. Almeida portrays the charge of tampering as very serious. And Judge, there's no question about it, a charge of tampering is very serious, but the state is a bit disingenuous in this particular situation. As the state is aware, maybe not Mr. Almeida currently standing before the court, but the Broward County Prosecutor's Office knows that at the arraignment on the tampering indictment, I immediately brought to Judge Cook's attention that count 1, tampering with a witness, was flawed. And Your Honor has Exhibit D2, although I have to refer to that first one before I go to D1. In D2, count 1 of the indictment reads that Ronald Tyrell committed a crime of the 2nd degree, quote, to wit, by employing Ronald Tyrell to convince the victim to drop charges in exchange for currency. And I advised Judge Cook, I said that's you can't employ yourself in committing a crime of tampering. So what I had done was I urged Assistant Prosecutor Lisa Comentucci to take a look at that count to see if we could see that, agree that it was flawed and possibly it could have charged some other party, and I think Mr. Smyers, with employing my client in a tampering. Having not received a response, and I believe Ms. Comitucci may have been on trial, I filed a motion to dismiss the tampering charge. I filed a brief in support of that motion. The motion was also sought severance of charges and also sought additional discovery. But the main thing was the motion to dismiss count 1, filed on January 22nd of this year. The state's response to that motion was due on February 13th. As I said, Ms. Comitucci was tied up in a jury trial, so she was unable to meet the deadline. And as you can see from Defense Exhibit D1, she was explaining why she couldn't meet the demands of my motion. She sent me that email 12 days later on February 25th, requesting my consent to adjourn the hearing, which I consented to. But further, if you can see in that email, Ms. Comitucci indicates in her email that, quote, also, if I can resolve the matter with Robin's client, meaning Robin Lord, Robin's client Smyers, this case will be dismissed as part of a global resolution. So it may be prudent to postpone the matter, meaning the hearing on my motion to dismiss the indictment. So Mr. Almeida's presentation to the court, in my opinion, is a bit disingenuous because we're looking to have the indictment dismissed against Mr. Tyrell. And number 2, it's defective anyway, so it should be dismissed by Judge Cook. And the prosecutor hasn't responded to my motion. So despite all of that, Judge, we're here now facing a potential violation of his pretrial release. He does have the new charges. Again, Judge, these are nonviolent drug charges. My submission to the court at this time is that Mr. Tyrell should be released in accordance with the recommendation of pretrial services on level 3 plus home detention and no electronic monitoring. If the court feels electronic monitoring is necessary, then of course that would be appropriate. That's it, Judge. Thank you.
Thank you, Mr. Spracco. Anything further, Mr. Almeida?
Yes, Your Honor. A few brief points in response. First, Mr. Spracco is correct. If I misspoke, I apologize. Mr. Spracco is correct that Mr. Tyrell was not actually arrested from the incident that happened on March 9th. However, he knew that he had CDS in the vehicle, and he knew that police seized that vehicle, and he knew that police were going to search that vehicle. So even though he wasn't formally arrested, he knew that charges were likely coming. And instead of going back to a law-abiding conduct or taking steps to get himself in compliance with his pretrial monitoring conditions, what did he do? There's no dispute that on March 12th, he's back caught using CDS, and this time, in fact, a higher quantity of CDS. Just off the top of my head, that was the day that they seized 192 wax folds of heroin, and his hand was seen in that bag when police arrived. So there's no dispute that this defendant just a few days later went back to doing the exact same conduct that got his car seized. So the fact that whether or not he was actually formally arrested, the state submits doesn't carry much weight. The court should give much greater weight to the fact that he went back to the exact same conduct just 2 days later. Judge, next, releasing this defendant would send a message that violating pretrial monitoring conditions don't matter. This defendant already is on level 3. Sending him back on the street while committing 2 separate sets of indictable offenses while on the highest level of release sends the message that pretrial monitoring obligations don't matter. With respect to the issue with the indictment, I haven't seen the indictment myself, so this is me speculating a bit, and if I'm inaccurate, I apologize. But with respect to the issue about the first count 1 in the indictment about Mr. Tyrell employing Mr. Tyrell to commit the offense, the only thing I can say to that, I note that there are 2 charges here. There's witness tampering and conspiracy to commit witness tampering. That may be a typographical error that they, in typing up the indictment, put the wrong person just typographically about who he conspired with. But that doesn't change the fact that there's also an underlying tampering charge. It's not just conspiracy, there's also tampering. So it's alleged that Mr. Tyrell engaged in direct conduct himself. And Judge, any talks about resolving that case or any pending motions in that witness tampering case are respectfully irrelevant to this proceeding, We're not here to address the merits of those pending charges. What's significant about those charges, Judge, is the fact that this defendant had second-degree charges pending. He was put on pretrial monitoring level 3 for those charges, and he committed or is charged with 2 separate sets of indictable charges while on release for those charges. And the state submits that's really the extent to which the court should consider those charges, because again, we're not here to address the merits of those charges. And with that, Judge, unless you have any questions, the state submits.
No, thank you. Anything further, Mr. Sporacco?
Well, just to comment briefly, Judge. I think the merits of the current charges are important. I think that we're looking to detain Mr. Tyrell on charges that the prosecutor appears to be looking to dismiss, which, in our opinion, the substance of these charges and the grounds for these charges are going to be hotly contested at a trial if it ever goes that far. So I think it is important. And secondly, my client, we're not asking my client to be released on the street. We're asking him to be released on home detention. He's going to be confined to his home. He's not going to be wandering around. So I think there is an additional precautionary measure that this court can take, short of detaining my client for the next 9 months. I'll call it 9.5 months, because of the coronavirus. Excludable time was 13 days, just ordered by the Supreme Court. So he's looking at another possible 9.5 months before he can go to trial on the current CDS charges. I think that's too burdensome, Judge. I would submit that he should be released on house arrest, home detention. Sorry.
Thank you. The court has 2 questions that it must answer. First, are conditions necessary to assure Mr. Tyrell's appearance in court, safety of the community, and conditions that will assure that he will not obstruct criminal justice process? Mr. Sporacco concedes, I believe, that conditions are necessary because he's stipulating or conceding to the recommendation of PML 3+, which is home detention. That's the first question the court has to answer, and the answer is yes. Conditions are necessary to assure those 3 factors. The second question is, will these conditions, namely home detention, will that provide reasonable assurance? Not assurance, not a guarantee, but reasonable assurance that he will appear in court and not put the community at risk and not obstruct justice. Now, how does the court answer that, Mr. Sporacco? Is home detention going to provide reasonable assurance? And the court has in mind that he was in somebody's shed. That's in a home setting, maybe not his home, doing something. So that's the court's concern. How would you respond to that, Mr. Sporacco?
Judge, yeah, and I think it is reasonable. He is in somebody else's location at that time. He wasn't in his own home. Again, this was an ongoing offense, in my opinion, Judge. He's living with, and I've been in touch with, I'm not sure if it's his significant other or wife, Lugiana Foster. She has been there day after day after day on this case. I have been on the phone with her. I have texted her constantly, 24/7, Judge. We've been talking to each other on this case. He is going to be living with her. She is going to make certain that Mr. Tyrell stays at home and complies there. Honestly, Judge, I had a recent conversation with her before we went on the record that Mr. Tyrell has to follow my advice, has to follow my directions, and that if we're ever going to get anywhere in this case, and I've got her secure promises to me that she is going to assist me and the court in making sure that Mr. Tyrell complies by staying at home. Judge, I think that that's enough. Home detention is enough to secure the safety of the community. And like I said, Judge, he has appeared at every court proceeding on the tampering charge. He's got, quite frankly, Judge, he's got me, and I think that that's an advantage. I am in constant contact with my clients, making sure that they get to court on time, making sure they get there, making sure that they do what they're supposed to do. The problem that Mr. Tyrell has is a substance abuse problem. But for that substance abuse problem, I think that we wouldn't be in this situation. So I think he needs attention, not detention. I think he needs attention to his substance abuse problem. So I do think that it would be reasonable to release him under home detention.
Is he taking any steps to address the substance abuse problem?
Judge, no. And well, actually, I think he is getting treatment at the jail right now. This is secondhand information from Ms. Foster that he is receiving, I'm going to guess it is some type of methadone treatment or some type of detox at the jail. So immediately after, at the time of his arrest, he was in the grips of his abuse problem. And this is what we are going to address immediately upon his release. And I think that, you know, I'm not going to forecast where this whole case is going, but, you know, we have the drug court and that's might be an end result for Mr. Tyrell.
Is he married?
Judge, they've called each other husband and wife. I can't confirm that. I believe Ms. Foster is his wife, but maybe Mr. Tyrell can chime in. I know he's on video.
Are you married, Mr. Tyrell? Do I have to do anything here to?
No, Mr. Tyrell, don't lean on the podium, please, and take a step back and try it again.
Are you married, Mr. Tyrell?
No, sir, but she's my boss.
All right, what is your address?
718 Lakehurst Road.
Do you rent or own?
Do I who? Rent.
Rent it or do you own it?
Rent.
Are you the tenant or is it your, what is the lady's name?
It's
Lugiana Foster.
Lugiana Foster, Loujeanna Foster, Foster. And before going on the record, I did confirm with her that particular address where Mr. Tyrell would be living with her, just her. She has no prior criminal convictions or any arrests of any kind. There are no guns in the house and no other people will be living in that house.
How long have you lived there, Mr. Tyrell?
About two years, I think.
Are you employed?
Yes, sir.
By whom?
By myself.
What do you do?
I cut trees, I scrap, I do a little bit of everything, plus I work for other people.
Is Miss Foster employed?
No, she just had a heart attack not too long ago.
Who else lives in the household?
Just me and her, except for my kids. My kids come over once in a while on the weekends. And my dog.
Thank you. Mr. Sparaco, are you indicating that Ms. Foster has agreed to accept responsibility for Mr. Terrell's compliance with any kind of order?
Absolutely, Judge. We've had multiple conversations since approximately March the 10th when we realized that there was a problem, and she is 100% on board.
All right.
Judge.
All right, anything further?
Yes. I'm sorry. Judge, may I respond briefly? Judge, so
yes.
Detective Lucas, the detective who authored the search warrant in this case, he was here on Wednesday doing the search warrant return, and he stopped at my office and spoke with me specifically about that address at 17 Lakehurst. Detective Lucas relayed to me, I'm offering to the court as proffer, that Foster and Tyrell have been squatting at that residence. Detective Lucas personally was at the residence, and he indicated that that house has no running water, the electric is off, and there was no electric meter. And he submitted to me that there is no evidence that they had a lease and are actually legally residing there, but instead are squatting there. The state submits that's not a reliable residence. And further, this court hit the nail on the head when it asked Mr. Sparaco about the March 12th charges happening in a residential setting in that shed when another person, Edward Johnson, was present. So this defendant has shown that he will commit home crimes or continue to commit crimes in a residential setting with another person present. So the fact that Miss Foster may be present, may be willing to take care of Mr. Tyrell, the state submits, is not an adequate condition based on the prior conduct here.
Thank you. Anything, Mr. Spracca?
No, Judge. I'm sure Mr. Almeida, as an officer of the court, is reflecting a proper conversation he had with Patrolman or Detective Lucas. I don't have anything at this point, Judge, to offer to the court as far as that particular address, only to relay my conversation with Ms. Foster that they both will be living there and nobody else will be permitted in that home.
All right, thank you. All right, the court will make some findings now. The court finds that the state has established probable cause that the eligible defendant committed the charged offenses based on the probable cause affidavits S3 and S5. Defendant is currently on monitoring level 3 and is compliant with all conditions, but for he shall not commit any offense during the period of release. That's a big violation in the court's opinion. But it is clear that conditions are necessary to assure Mr. Tyrell's appearance, the safety of the community, and that he will not obstruct justice. In view of his history of general compliance, there is a condition, namely monitoring level 3+, that arguably would reasonably assure his appearance, the safety of the community, and that he will not obstruct justice. That condition has not yet been imposed. The court also takes into consideration the history and characteristics of the defendant, primarily that he lives with Miss Foster and she has agreed to accept responsibility to see that Mr. Tyrell complies with conditions of release if he is on home detention in her de facto home. The
Yes, he's up there for detention hearing.
representation is that Mr. Tyrell and Miss Foster had lived at that location for about 2 years, and that Mr. Tyrell is basically self-employed as a general handyman, scrap person. So based on those findings, the court is going to deny the state's application for pretrial detention and find that there is a condition that would reasonably assure his appearance, the safety of the community, and that he will not obstruct justice. And that is based primarily on the fact that he is compliant with the great majority of conditions that have been imposed on monitoring level 3, and that home detention should be imposed to exhaust every reasonable attempt to avoid detention. Very important to the court's decision is the fact that there is no new criminal activity flag for violence. There is a recommendation of release on with certain conditions. The current charges are 8 in number. The highest degree is 3rd degree. None of them are violent charges, nor are they NERA. They do not involve weapons or domestic violence. So based on that, again, the court's going to deny the state's application. Now, Mr. Terrell, you may consult private counsel if you desire. You already have private counsel, and you may appeal this order within 7 days. I'm going to place Mr. Terrell on monitoring level 3+, which is home detention. The conditions of the prior release order shall remain in effect, which I'm sure includes no contact with the victim or victims. His next court date on the indicted matter is, just for the record, April 27 at 9 a.m. for an initial conference. He also has a pre-indictment conference before Judge Covert on May 6th at 9 a.m. As far as pretrial services, I'm going to inform everyone that, again, the level of monitoring is PML 3+. Pretrial services will provide further instructions when you report. I will indicate on the release order that you must call pretrial services the next business day for an intake, and that is when reporting schedules will be determined.
Okay.
Anything further from counsel?
Nothing further, thank you.
Nothing further, Judge, thank you.
How about anything?
We need to address the motion to revoke specifically
Yeah.
and the violation.
Yeah. Now, second, there is the a motion to revoke,
Please, I should have said please, I'm sorry.
release. I have the motion, so I'll hear from the state first.
Thank you, Judge. In light of the detention decision and taking into consideration the practical effects of this, state would move to withdraw the motion. The state would ask that he be released consistent with the pretrial detention hearing on level 3+ monitoring. And last, the state would ask that you find him in violation of his monitoring for incurring the new charges while on pretrial release.
Mr. Sparaco?
I have no objection to that order.
Very good. Then I will make the following order and findings. The defendant violated a condition of pretrial release by a preponderance of evidence. Namely, he incurred new charges. There is probable cause to believe that he committed a new offense while on pretrial release, and that probable cause is based on the probable cause affidavit. The motion is denied. It's withdrawn, I'm sorry. Motion is withdrawn. By the state without objection. And again, you may consult with private counsel, and you have a right to appeal, Mr. Tyrell. All right, anything further?
No, Your Honor.
How about, do we have anything? We need anything? We got everything covered?
Yes, thank you.
All right, thank you, counsel.
Thank you, Judge.
So what does that mean, Mr. Sparko? Thank you, you have a good day.
Have a good day.
Thank you.
Okay, let me get this stuff out of the way here. Now the orders, how's that all work?
Are they filled out?
I'm going to, I will. I'll fill them out and then I'm gonna practice putting it on, on the jukebox, so, but I'll fill them out.
Okay, good, because, Krista from pretrial will come up and pick them up. You want me to tell her that you'll be in chambers with them?
Chambers, yeah.
In your chambers?
My chamber, yeah,
Okay.
please do, thank
You
you.
pointed back, so I just want.
Yeah, I don't want to take anything that belongs to Judge Tarantino here. Okay. Thank you very much.
Thank you.
Welcome. Done. Finally.
Oh, I just texted you, Judge. Stay safe, Judge. It was nice working with you.
Same. I appreciate it.
My
Take
pleasure.
care. Take care.
So
Can't do that right in the middle court.
We'll be right with you, BCJ. Judge Tarantino's on his way back.
Do you know who's next on the list so I can bring them in?
I don't know. Brandon
Okay.
or Mr. Russo, do you know who's next?
I don't know who's next. May I suggest maybe either Means or Hubbard, just because older cases that haven't been postponed.
Okay.
Okay, Mr. Rizzo just stepped out, so.
Means has
Sorry.
been with the council though, if I recall, and I don't know if it's connected right now. So maybe Hubbard.
Is that Mr. Corby?
Yes.
Okay.
I spoke with him yesterday, and he's aware that these are being done via video, and he made representations that he'd be appearing via video. So.
Okay.
Wait till Tarantino comes back.
Wait a minute. Brandon,
Yes.
you postponed Wagner and who else?
Kurz.
Yes, sir.
Okay.
Tony.
Not
give
Antonio
the
Allen,
conference-
right?
Correct.
think that Alan was postponed. I made myself a note that he was postponed.
Gotcha. I mean, maybe, I don't know if there was a defense request, but not from the state. I'm ready on it.
No, okay.
Then who's postponed?
You didn't postpone Mr. Allen, did you, Mr. Rizzo?
I didn't, but I was going to ask for a postponement because for some reason he wasn't interviewed.
Okay. All right, well, oh, here's my, I'm sorry, I'm talking to myself. I'm working on the fly here, nothing was prepped for me, and I made a note that said Alan postponed, but I think I meant first. All right, let's see.
When was Mr. Allen's first appearance originally scheduled? Do you know?
I believe on the 18th.
All rise.
Tuesday?
We have, this is a Zoom call, and it is scheduled to end at 1 PM. Do you think we're gonna break for lunch at 12:30, or we just?
I'm absolutely going to break for lunch at 12:30. Yep. All right, I need to catch up on paperwork. Mr. Almeida, are you seeking to postpone any of the, I never asked you that question. Are you seeking to postpone any of these other cases?
No, Judge, I'm ready to proceed.
Okay. So that means you're ready to proceed on Sweat, Thomas, Means, Hubbard, and Allen.
Means Mr. Corbier.
Your Honor, I'd have to ask for a new date on Mr. Allen.
Okay, let's do that now so he can be released. All right, so we'll go on the record. And let me just get my file here, guys. Let's see. See, one of the problems, I'm behind on my paperwork, and I do have to catch up. Cases postponed. All right, we are talking about Antonio Allen, W 2020, 142-317, and Mr. Almeida, Mr. Rizzo appear respectively. Mr. Rizzo, do you waive Mr. Allen's appearance?
Yes, Your Honor.
Thank you. The state postponed this on Wednesday, the 18th of March to today. Mr. Rizzo, you have an application, sir?
Yes, Your Honor. I'm not sure why he wasn't interviewed. I do most of the interviews. Sometimes they're interviewed by other people, but there are no notes such as I take and the others take that indicate he was interviewed. And I'm reluctant to proceed with a detention hearing without him being interviewed.
It makes perfect sense, sir, and you didn't even really need to give me a reason, but we'll postpone it. Is Tuesday okay?
That would be fine, Your Honor.
Okay. The Allen case is postponed. Thank you for chiming in on that. We have left now Means, Hubbard, Thomas, and Sweat. Can you give me 3 minutes, guys? Let me just catch up with all my paperwork because I tried to move things out of here, and I have to just get things done before it totally gets away from me.
Sure. Judge,
Your Honor, with regard to Mr. Means, does he have a private attorney who's going to appear for him today?
Yes, he has Joseph Corby as his attorney.
Okay. Thank you.
Judge, if you're taking a minute to fill out paperwork, is it all right if I step out for 1 minute?
Yes, sir.
All right, thank you. I'll be right back then.
Thank you. Okay. 20. All right, so we got that one. Okay, so then I also have Sweat. Webb. Okay, Webb is, well, I gotta fill out Wagner. Was Michelle up here?
No,
Okay.
Krista came up.
Krista, oh, is she looking for files?
I gave her the one and she's fine.
Okay. Muniz and Hubbard. All right. Probably I'm going to ask to do Hubbard next unless somebody has, but I have to write.
Actually, Mr. Almeida had recommended that as well.
Okay. Great minds think alike.
Yeah.
When Krista came up, was she looking for these files?
Well, I gave her the one that was, I think it was McLean.
Okay. Because I now have like 4 more for her.
Okay, because I email her when we're done. I usually wait until you put them down, but I wasn't
Yeah.
paying attention because,
Yeah, we're
as I
just.
said, I'm on the fly today. Nothing was pressing
Yeah.
me, so I'm trying to do 19 things at once. I'm doing pretty good, but, you know.
Yeah.
Sometimes I make a mistake. I thought I was wrong once, but I was mistaken.
Last time I heard that, I fell off my dinosaur. Web is.
Right now?
Web is PIP date. Web is a PIP date, right?
Right, 5:06, 9 a.m.
Thank you. I went back there. I tried to see if I could get this on live stream.
Uh-huh.
So I went on YouTube and I put it in, and I had to put in Burlington County NJ detention hearings live streaming, and it told you to go to another website that is for live streaming.
Uh-huh.
And when you go to that, it's blocked from the computer. But you can get. I didn't really know until now that you could, on my computer, I can get YouTube videos. They shouldn't do that. That's like very distracting. I could spend all day watching YouTube videos.
Yeah, I could too. All right, let's see.
Okay. So Sean Hubbard, do you think we should do that one next?
Yeah, state's ready to proceed on that, Judge.
All right, you ready, Mr. Rizzo, on Sean Hubbard?
Yes, I am, Your Honor.
All right. That one.
Sean Hubbard, coming up.
Thank you, sir.
Online minutes or live minutes are so sensitive. Like if I'm scrolling and I click something, it puts an X in a box.
Judge,
I'm double checking this thing.
copies of the complaint, the 2 warrants, and the CCH.
Say that again, Mr. Almeida.
For purposes of the exhibits, before we begin, do you have the PSA, the 2 warrants, and the CCH?
I think I do. Let me just check. All right, I have the public safety assessment. I have the 2 warrants, and attached to them are the probable cause statements. And I have the CCH.
Great, thank you.
Okay. And I'll just, instead of printing them out, I'll just mark my copies that I have. Mr. Who? Oh, you think so? Yeah, okay. Well, we got that. Right, Mr. Hubbard, is that you, sir?
Good morning, Your Honor.
Morning, good morning, sir. Mr. Hubbard, I see you're standing, and you're welcome to do that. If you would prefer to sit, pull up a chair. It's up to you, depending on how you feel.
I'm feeling fine.
Okay, sir. But you can change your mind, too. I just don't want you to be, I have no idea of how you are physically, so I don't want you to have any physical issues.
okay.
But we're going to proceed now with your hearing, Mr. Hubbard. This is the Sean Hubbard case, W2020-209-313 and W2020-210-313. This was postponed from 2 days ago, Wednesday, the 18th of March, by the state for discovery. This is also a matter in which the state has filed a motion for pretrial detention. I think we are ready to proceed today. May I have your appearances, please?
Thank you, Your Honor. Assistant Prosecutor Brandon Almeida for the state.
Morning, Your Honor. Anthony Rizzo on behalf of the defendant from the Public Defender's Office.
All right, thank you. Are we ready to proceed, gentlemen?
State's ready.
Okay, very good. Mr. Prosecutor?
Thank you, Your Honor. The state would move to admit into evidence 6 exhibits. The state would ask that the court mark Exhibit S1, the public safety assessment. The state would ask the court to mark as Exhibit S2, warrant 2020-209-0313. The state would ask that S3 be marked as the affidavit of probable cause for the same complaint warrant. They would ask the court mark as Exhibit S4, warrant 2020-210-0313. S5, the affidavit of probable cause for same. And last, the state would ask the court mark as Exhibit S6, the defendant's criminal history.
S1 through 6, Mr. Rizzo, any objection? S1 through 6?
No, Your Honor. Thank you.
Okay, S1 through 6 are admitted in evidence. I need a few minutes, gentlemen, to see what these things say, so bear with me. All right, Mr. Prosecutor, sir?
Thank you, Your Honor. Nothing further from state.
You want, are you ready to, nothing further from the state, is what you said. Okay.
Thank you.
All right, Mr. Rizzo?
Can I make argument, Your Honor?
Yes, sir.
All right. Your Honor, this seems to be a fairly unique situation. This gentleman's scores are a 2 and a 2. Significantly, he has no prior violent history of offenses. He has no failures to appear in his history, either earlier than 2 years or later than 2 years. This appears to be a jealous fit that he's accused of. I realize that there was violence involved and some words that were also said in the way of terroristic threats. And there's also a weapon involved. However, given the fact that he found his separated wife with her boyfriend and has had difficulty apparently in coming to grips with or coming to terms with the fact of their separation, I do think that given the unique situation here, that some level of pretrial monitoring would more than assure his appearance in court, since there's been no history of failures to appear, and would also assure that there's no danger to the community, and a no contact order for the boyfriend as well as for his separated wife would assure their safety as well.
Can you tell me about his stability in the community, if you know that, any of that, Mr. Rizzo?
I apologize, Your Honor. Yes, I do have some information on that. He's 40 years old. He has no criminal history. He's a high school graduate. He worked for public service, has been working for public service for the last 4 years as a measurement technician. Before that, he was gainfully employed as a driver by Federal Express. He worked there for 3 years. Before that, he worked 14 years for BJ's Wholesale in their warehouse. He has 2 children. A 7-year-old is with his current wife and an 11-year-old with his previous relationship. The 11-year-old lives in Burlington and he sees her several times a week. He pays $88 weekly from his paycheck, directly from his paycheck to the support of the 11-year-old. He has no health issues. He's not on any medications for any psychological difficulties.
Thank you. Either counsel, can you comment on the statement in the both affidavits of probable cause towards the end that Crawley, referring to Mr. Crawley, the male victim, did not wish to cooperate with the investigation? Anything on that, Mr. Prosecutor?
Nothing from the state, Judge.
I'm sorry?
Nothing from the state, Judge.
Okay. Anything on that, Mr. Rizzo, that you want to comment? You don't have to.
Well, I would say, Your Honor, that's fairly interesting. It seems to mitigate any aggressive behavior on my client's part. We don't know the entire story of what happened there. But given the fact that he's not interested, the victim, one of the victims, is not interested in pursuing this matter, I think that goes to support my previous contention that my client's certainly not in danger of not appearing at subsequent court hearings. And given a no contact order, the uniqueness of this particular situation, my client's absence of a violent history before this incident, and his stability in the community as evidenced by his support of his child, as well as his continuous employment for very protracted periods of time with various employers, all go to show the uniqueness of this particular situation, and a level of monitoring should guarantee that there will be no further problems.
Okay, thank you. Thank you, gentlemen. This is the pretrial detention hearing for Mr. Sean Hubbard. In this case, the state has filed a motion for his pretrial detention, and we've had the hearing. The court, first of all, finds probable cause for the offense. That's based, but both sets of offenses, that's based on exhibits S3 and S5. The court does have a well-grounded suspicion that these offenses occurred. We know that probable cause calls for far less evidence than is needed to convict at trial. At trial, the standard is proof beyond reasonable doubt. We did not have a trial today. This is not the determination of guilt or innocence. That comes later down the road in this case. The court is concerned about the safety of the victims, but based on the overall picture, the court is going to respectfully deny the motion for pretrial detention. The primary reasons are that currently Mr. Hubbard is not on probation, parole, or pretrial monitoring. He has a very minor criminal history. He is 40 years old. He does have some prior domestic violence involvement, all appear to be from years ago. In addition, Mr. Hubbard, the public safety assessment recommends monitoring level 1 with scores of 2 and 2. And he does have steady full-time employment and a solid work history. And he does have some ties to the community with children. The court therefore will find that it is appropriate to give Mr. Hubbard the chance to be on pretrial release, and that the presumption in favor of his pretrial release weighs very heavily here. Mr. Hubbard, I'm going to deny the motion. I'm going to have you released, order that you be released. But there are conditions of release, sir. I want you to be successful. I want people to be protected. You want to be successful in following these conditions.
Yes, sir.
So all things you can do. You're a mature guy. You know what's going on. And
Yes.
You're a solid guy with work history and presence in the community. So I'm confident that you're going to be able to comply with these conditions. But as I tell everybody, if you don't comply with these conditions, sir, the prosecutor can file a motion for your pretrial to revoke your release. So then you go back, if we would have a hearing. The result of the hearing could be that you would go back into jail, and you don't want to have that happen. So, sir, please listen to the conditions. The most important condition is no contact with either victim.
You got
no contact with Mr. Crowley or no contact with the lady. Now, is this lady, just answer a very short question, is this current wife or former wife?
Your Honor, this is my wife of 10 years, and we are still currently married as husband and wife with a 7-year-old daughter.
So, sir, you're not to have contact with this lady. You have one child with her, correct?
Yes, sir.
Okay. Child lives with you or with her?
The child was with my father-in-law, her father.
Okay.
The night of the incident.
Do you have parenting time with the child?
I see my daughter every day. Our relationship is, we're not separated, but I pick my daughter up and I'm at that address in Marlton every day with my daughter and my wife. There's no separation.
Well, you are ordered. Okay. Well, now we're gonna have a we're gonna have a talk about this, because you're ordered not to have contact with your wife.
Yes, sir.
And that means, okay, so let's talk about what that means. Not in person, not by phone or text, not by email, social media, or anything over the internet, not by letters or notes. And if she calls you because she wants to see you, or she wants money, or whatever reason about the child, you are not to respond. And
yes,
the burden's
sir.
on you, not her. Okay, burden's on you, not her. Is there a restraining order, sir?
There's a temporary restraining order, I believe, and I believe we're supposed to be in court Monday. But I'm not sure of the court. I'm not sure of the court because of everything that's going on. I'm sorry.
Okay. Yeah, you're right about that. You don't have to lean forward, because I can actually hear you better if you stand straight up.
Okay.
Okay, so the restraining order is a temporary restraining order. It remains in effect until there's a final restraining order hearing to see if the restraining order is made final or if it's dismissed. If it is still in place, either temporary or final, if you violate that restraining order and have contact with her, what will happen is that the police will charge you with a separate offense of violating restraining order, and then it just starts to get bad, and you don't want that to happen. If the restraining order is dismissed for any reason, you are still not to have contact with her, because that is a condition of your release. You understand that, sir?
Okay, yes.
All right, now, yes or no answer. When the incident occurred, was your daughter there?
No, she was with my father-in-law.
Yes or no answer. Okay, just yes or no, sir. Yes or no answer. Is the temporary restraining order, have you seen a copy of it?
Yes.
Does it include your daughter as a protected party?
Yes, it's checked off in a box.
Okay, her name is on there, right?
Yes, her full name.
Okay. So that means you can't have contact with her as long as the restraining order.
Yeah, I was aware of that. I was aware of that by the Evesham Police Department.
Okay. So what? And now let me ask you questions about. Hold on, sir. Your father-in-law. Your father-in-law lives at what street? What street is he on?
He lives in Morristown, New Jersey.
What street?
I'm not sure. It's off of 2nd Street near the library. He was an ex-policeman, so I'm not sure.
What's his name?
Randy Pugh.
Okay, sure. I know exactly what you're talking about. So that's where he lives.
Yes, that's where.
And is the daughter with him?
He takes care of her. He picks her up from school, and after school, he brings her to his house, and that's where I would pick her up after work to bring her back to Marlton.
Okay. Okay. And I actually met her years ago. She's a beautiful girl.
Layla or Grace?
But anyway, that's just an aside. That's just an aside. Okay. Where does your wife live? What street?
She lives in 23 Nanticoke Court in Marlton, New Jersey.
Okay. And where do you live?
I moved. I live in East Hampton now, 31 Clemens Boulevard, East Hampton, New Jersey.
All right. They have 32 Clemens Boulevard, but you're saying it's 31?
Yes, sir. It's 31.
All right, 31.
Your Honor, in all my belongings.
Hold on, sir.
All right.
31 Clemens, Clemens Boulevard?
Yes, in East Hampton.
No T, right?
Currently, no T. I'm staying with my sister as of now.
All right. Sir, do you have personal property in Marlton?
Yes, I have all my belongings in Marlton. The officer said whenever I was to contact them to go get my stuff out of the house and then to give them my house key back.
Okay, so you have that under control. Do you have a vehicle in Marlton?
My vehicle is currently parked at my sister's house.
Okay, so that's easy. Go through the Evesham Township Police to get your stuff back.
Okay.
Okay, and as far as contact with you can't see your daughter unless the restraining order is dismissed. And then if you do, because I'm not going to prohibit you from seeing your daughter. I'm prohibiting you as a condition of your release from seeing your wife or Mr. Clemens, I think. I forgot his name.
Crawley.
Mr.
The
Crawley.
guy she's having an affair with, yeah.
Sir, you don't have to interject facts that are really not pertinent to your release, okay? Don't do that, okay?
Oh, I'm sorry.
Okay, that's like a self-serving statement. I'm not going to be the guy who's going to try your case. So anyway, getting back on track here. If there's restraining order is dismissed, then you can have contact with your daughter. You're going to have to do it through intermediaries. You can't do it involving your wife being present. So let me give you an example. Let's say your daughter is with your wife. You don't go there and pick her up. You don't go there and drop her off. You go through intermediaries. You might be able to have help with Mr. Pugh or somebody else as an intermediary, but you're not ending up in the same place as your wife, and the burden is on you to do that. You understand that, sir? Okay.
Yes.
So I just want to make that clear. So you understand no contact, obey all restraining orders, even if restraining orders dismissed, still have no contact. Sir, the other conditions are you are to not have any new offenses. You're to notify pretrial services if your address changes. You're also to attend all court appearances. Your next court appearance is on May 6th, 2020. And is there a second degree?
Yes.
And that is at 1:30 p.m. You would come here to the Burlington County Courthouse. You will go to the 7th floor. You will see Judge Morley, and that will be at 1:30 p.m. courtroom 7A. If you miss that court date or any other court date, a warrant will be issued for your arrest.
Okay.
Sir, you are also to not possess firearms, destructive devices, or dangerous weapons. Do you own any?
Yes, sir.
Do you have a firearms purchaser ID card?
No, I don't have any of that.
Okay. Do not get any guns or anything like that. You are on monitoring level 3. That requires weekly reporting. you have to come here to the Burlington County Courthouse the first time. The second week, you call in. The third week, you come in. The fourth week, you come in.
Your Honor, can I say something?
Coming in, calling, coming in, calling. Hold on, sir, hold on.
Okay.
Now, because of the new situation all over the world, Pretrial Services is modifying that. You have just follow their directions. They'll probably have you call in once a week most of the time. They may request you to do some kind of a video link up or a Skype or something like that. So just be flexible with their instructions. But the idea is that in one way or the other, you are reporting to Pretrial Services once a week. You
Okay.
understand that, sir?
Yes.
Okay. Do you have any questions about that?
Yes. So, I work for PSE&G. Where I work at is in Union County. I work in Union, New Jersey, up North Jersey. So I don't know, like I'm like an hour away from here. So it would be hard for me to get down. Well, I can definitely call.
You are one of many people who have that kind of challenge because you're working.
Okay.
Now, they do have later hours on Wednesdays.
Okay, all right.
And they are flexible. They do a very good job. They want you to succeed. So talk to them about the ins and outs of your own personal situation, your availability, and things like that. You may end up maybe reporting to work late one morning or leaving work early. That's probably easier said than done. But it's a priority, sir, because if you violate these conditions, even if you miss reporting, the prosecutor is going to file that motion to revoke your release, and that would not be a good thing. So, somehow make it work. But I have people tell me this all the time. I tell them to discuss it with Pretrial Services, and it seems that they're able to get some sort of an arrangement that will make things happen as they should, okay?
Now, will I get something from pretrial in the mail, or how's that work?
Well, you'll have an order that will list the things that I said. You will also have it mailed to them, and let's make sure we let them know that it's 31 Clemens Boulevard. What's your phone number, sir, please?
Phone number is 856-834-0173.
All right, thank you, sir.
You're welcome.
All right. Any more questions,
And I have
Mr.
one more
Hubbard?
question. Yeah, one more question. I know that this marriage is now definitely going to a divorce. So what happens if we're still on restraining order when we have to go seek divorce counsel?
That is a lawyer's question, but I'll tell you that no matter who people are, who you are, or what's going on, you don't have the same attorney. You'll have your own lawyer for a divorce,
Okay.
and your wife will have her own lawyer. That's the only way it can work. So, in addition to dealing with these criminal charges, you probably want to talk to a lawyer who does matrimonial law or divorces. There's lots and lots of lawyers like that out there, and it's probably a good idea to have an earlier appointment to see what your rights and your responsibilities are. Okay, sir?
Thank you very much.
All right. Good luck, sir. I know you can make this work, but I just want to emphasize, be very, very careful about contact with either victim, particularly your wife. That's going to be an issue if that occurs. Okay.
Thank you, sir. Have a good weekend.
Your Honor,
Yeah,
may I
Mr. Rizzo, sir.
Yeah, Your Honor, you pointed out rightfully that he's got to make contact arrangements with his wife in order to see his daughter, for visitation, picking his daughter up and dropping her off. But I think he should also be told that he's not to have any indirect contact with her through a third party other than to make visitation arrangements.
Yeah, I think that's a good point, Mr. Rizzo. Just to be clear, Mr. Hubbard, be careful in be careful in indirect contact with your wife. Don't have people contact her for you or anything else unless it's visitation arrangements. And those visitation arrangements are suspended during the while the restraining order is in effect. That restraining order may be permanent, so you really need to be careful.
All right, I understand.
All right. Thank you, Mr. Rizzo. All right. Good luck, everybody.
Thank you. Have a good weekend.
You too, sir. All right, let's go on to Thomas, Fred Thomas.
Okay.
Right, and means, right?
Yeah, I'm gonna do Thomas, then me, then Sweat, then me, exactly in that order. Glad I thought of it. Mhm.
Yeah, I don't know what's going on with you guys, man.
All right, you are Mr. Fred Thomas?
Yes, sir, Mr. Chair. I mean,
All right,
Your
Mr. Thomas, we're about ready to begin the hearing. You're welcome to remain standing, or you can pull up a chair, and you can change your mind. I don't want to have you stand if you're physically, it's going to pose a challenge for you. So just so you know that, okay, sir?
Yeah, I'm all right.
All right, but if you start getting tired, feel free to take a seat. I don't want to force anything on you. All right, we are ready now to begin the Fred Thomas hearing, W 2020-81-0320. Mr. Thomas had his first appearance earlier this morning. The state has filed a motion for his pretrial detention. May I have your appearances, please?
Thank you, Your Honor. Assistant Prosecutor Brandon Almeida from State.
Good morning, Your Honor. Anthony Rizzo from the Public Defender's Office on behalf of Mr. Thomas.
Thank you. Mr. Almeida, you ready to proceed, sir?
Yes, Your Honor.
Okay,
Your
go
Honor,
ahead.
The state would ask that the court mark for admission evidence exhibits S1 through S4, with S1 being the public safety assessment, S2 complaint warrant 2020-81-0320, S3 the affidavit of probable cause for same, and S4 the defendant's criminal history.
All those are marked as exhibits. Mr. Rizzo, any objection to S1 through S4, sir?
No, Your Honor. Thank you.
Okay, S1 through S4 are admitted in evidence. Now, I need a few minutes just to go through all the exhibits, so bear with me.
Sure.
We're still going to be on the record.
I'm cool, I understand. I want to check this shit out. So much devil worship and evil stuff going on in the world. Yeah, I see it. It's crazy. The same person I did this, I just put litigations in.
I'm going to say, Mr. Thomas, the microphones apparently are very sensitive, and you appear to be talking probably to yourself, which is, you can do that.
No, I was talking to the officer, I apologize.
Oh, okay, all right. I just want to have a clear recording, and I don't want you to say something that could not benefit you, so that's why I'm mentioning that to you.
No, I was
okay?
asking the officer something, I apologize, yes.
That's okay. All right, Mr. Prosecutor, anything further?
Yes, Your Honor, thank you. First, with respect to probable cause, the state relies on the affidavit of probable cause admitted into evidence. With respect to detention, the state notes the PSA scores. The defendant scores a 4 for failure to appear, 6 for new criminal activity, the highest score possible, and there is the presence of the new violent criminal activity flag indicating an elevated risk of violence. Taking these into account, the recommendation of pretrial services is no release. In the current matter, there are 3 charges before the court: terroristic threats, possession of a weapon for an unlawful purpose, and unlawful possession of a weapon. These charges stem from an incident where the defendant was allegedly upset with the manager of the motel complex over an eviction. The defendant proceeded to walk to the office but was unable to enter because it was locked. While he walked there, this defendant was carrying an Easton baseball bat. He walked around, brandished the bat, and is alleged to have threatened the victim multiple times with the bat. And there were other witnesses who corroborated the victim's account that the defendant threatened the victim while carrying that bat. With respect to the weight of the evidence, we have observations from law enforcement officers, including body-worn camera footage. We also have a 911 call, multiple witness statements, and the physical bat was recovered. Looking at this defendant, Judge, this is someone who's clearly a career criminal. This is someone with a criminal record spanning from 1984 through the present, totaling 38 convictions. And among those convictions, this defendant has a history of violence and CDS abuse. At the time of this offense, this defendant had 2 pending charges, 2 disorderly persons offenses. Most recently, however, he was arrested on February 24th, 2020. So that's concerning because that was just weeks prior to the incident offense. And he also had a shoplifting pending from 2015. He has
Not me.
14 prior disorderly.
You got the wrong charges.
Excuse me, Mr. Thomas, you will not interrupt, please. Please remain quiet.
I apologize, sir.
while
He just said a
Attorney
couple
Turner are
wrong
speaking.
things. Everything was wrong.
Well, sir, again, sir, your attorney will take
I'm
care of
sorry,
that,
I
but you are
apologize.
to not disrupt the hearing. And if you do it again, I'll just have them remove you from the hearing. I think you want to listen
No,
to
sir,
this.
I
so,
apologize. You got it.
All
But
right,
if you hear
so
something
let's
wrong.
not hear anything further, okay, sir? Go ahead, Mr. Prosecutor.
Thank you, Your Honor. Looking at his prior convictions, by my count, there are a total of 14 disorderly persons convictions from 1984 through 2014. Among these, there were 3 simple assaults, 3 CDS-related convictions, and 5 convictions for what I would categorize as obstruction-related, including 2 for resisting, 2 for obstruction, and 1 for hindering. Additionally, by my count, there are a total of 24 prior indictable convictions. Among those, I would classify 8 as violent. By my count, there were 7 aggravated assaults and 1 weapons offense, collectively making the 8 violent offenses. Additionally, there were 6 obstruction-related convictions, 1 for contempt, 1 for second-degree eluding involving the risk of serious bodily injury or death, and 3 for aggravated assault on a law enforcement officer, collectively making the 6 obstruction-related I refer to. And there are also 8 CDS-related, including 3 for distribution. And among those 3 for distribution, there were 2 second-degree convictions for possession with intent to distribute. Additionally, the CCH is showing 1 Pennsylvania arrest for receiving stolen property in 2010, although the disposition is unknown, so it's hard to count that as a conviction. However, as I'll get into later, the state would submit that the court should at least consider that there was 1 out-of-state arrest. Looking at the 3 factors for detention, first, the state submits that there is a high risk of failing to appear based on this defendant's PSA score of 4 out of 6, as well as his 12 prior failures to appear, all of which were older than 2 years. The state submits there's also a high risk of obstruction here. First, including both the disorderly person and the indictable convictions. By my count, there are 11 obstruction-related convictions. Among those, 5 indictables. Among the indictables, 1 second-degree eluding and multiple aggravated assaults on a law enforcement officer. Additionally, Judge, there are, by my count, a total of 7 aliases listed on the CCH. I mean, there's some variations of Fred Thomas. I see Fred J. Thomas, Fred M. Thomas, Frederick Thomas. So I wouldn't count those against Mr. Thomas in fairness, but I see and Andrew Brown, Keith Brown, John Clark, Malik Jones, and a Kareem Thomas, which certainly aren't Fred Thomas. Additionally, there are a total of 8 different social security numbers listed. And so this is just further evidence that this defendant will do anything to avoid detections and take steps to obstruct the justice process. And taking this into account, the state submits there's a high risk of obstruction here. And last, the state admits there is a high danger to the community. First, this defendant scored a 6 out of 6 for new criminal activity, and there's also the new violent criminal activity flag. This defendant is someone with a history of violence, as I touched on earlier, and now we have more violence here. And this was over an eviction. This defendant got so angry, purportedly over an eviction, that he grabbed a baseball bat and went to threaten the property manager at the motel. In addition to his prior convictions for violence, this is someone also with a domestic violence history. By my count, there are 4 active restraining orders and 2 dismissed. And just looking at the predicate acts, we see further patterns of violence. The predicate acts include assault, harassment, terroristic threats, assault, and assault. So there's a clear pattern of assault and terroristic threats in his domestic violence history. Additionally, looking at a CCH, I note a violation of probation in his history, which is evidence of his non-amenability to pretrial release conditions. And last, Judge, taking his criminal history into account, this is someone who's clearly not deterred by his extensive criminal justice conduct. He has a total of 43 New Jersey arrests and 1 Pennsylvania arrests and 38 convictions. And his first arrest came at age 18. So he has averaged, he's 53 years old now. So he averages more than 1 arrest and conviction per year as an adult. And among those 38 convictions, again, there's 24 indictable convictions, and he served a total of 22 sentences of incarceration, including multiple lengthy sentences. And he was just arrested, as I touched on earlier, weeks before this offense on February 24th, 2020. So, Judge, based on this person's record, he's clearly a career criminal, and the state submits that there is no alternative to detention because if released, he's shown that he will continue to offend. Judge, for these reasons, we're asking that you follow the recommendation of pretrial services and detain Mr. Thomas.
Thank you, sir. Mr. Rizzo.
Thank you, Your Honor. My client obviously has a long history that the prosecutor has just recited. However, we don't think that's dispositive of what should be done here today. In the way of background information, just briefly, my client's 53 years old. He had a year and a half of college. He studied drug counseling at that time. He's currently single. His children are grown up. His last employment was with Mearshawn Concrete. That was an employment that lasted about 3 months last summer. The critical thing here this morning, Your Honor, which is what I'm greatly concerned about with the specter of continued detention, is that he's had pneumonia twice before. He was concerned about pneumonia this time, as was his doctor. His doctor, when I interviewed Mr. Thomas on, I think it was Tuesday, his doctor wanted him tested, and he was supposed to go on Wednesday for testing, which obviously has not occurred. So given that, Your Honor, before I go on to some of the aspects of his record, given the fact that we've got this coronavirus floating around and my client seems to be in jeopardy of pneumonia already, and we don't know when that's going to hit the jail or if it has hit the jail already and just hasn't surfaced, I would think that a detention outside of the jail under monitoring level 3+ would be more than adequate to allay the prosecutor's concerns. With regard to the public safety assessment, he did score a 4 and a 6. However, as the prosecutor pointed out, he had no failures to appear over the last 2 years. There was no firearm involved in this case, nor a history of firearms as far as I could tell. He was not currently on probation or parole when he was picked up, and he was obviously very upset about the eviction that was looming over his head. So given those factors, Your Honor, we do ask for a monitoring level 3+ in order to be sure that he will show up in court and that he will not offend again while he's out.
Thank you, sir. Any response from the state?
Just briefly, while the state's certainly sensitive to the ongoing pandemic, respectfully, the state submits any medical conditions that don't affect any of the relevant factors for detention, namely risk of appearing, risk of obstruction, or danger to the community. Whether or not somebody has a medical condition doesn't adequately assure that he'll protect the community. Certainly, someone with a record like Mr. Thomas's, especially, the jail has the ability to provide medical treatment for inmates, and thus that really doesn't have a bearing on any of the factors for detention.
All right, thank you. Mr. Rizzo, any final words?
Well, I think a monitoring level of 3+, confining him to wherever he's going to be living, would more than adequately deal with the prosecutor's concerns.
All right, thank you, gentlemen. This is the pretrial detention motion for Mr. Fred Thomas. The state has filed a motion for his pretrial detention, and we've had the hearing. First of all, the court does find probable cause for the offenses based on Exhibit S3, which is the probable cause affidavit, which includes a preliminary law enforcement incident report. The court is satisfied that after reviewing these documents, the court has a well-grounded suspicion that an offense has occurred. We know that probable cause calls for far less evidence than is needed to convict at trial. At trial, the standard is proof beyond a reasonable doubt. We're not trying the case today. It's just to see if there is probable cause, and the court does have a well-grounded suspicion that there is. Separate and apart from that, the court finds by clear and convincing evidence that there is no amount of monetary bail, non-monetary conditions, or combination of bail conditions that would reasonably assure the defendant's appearance in court when required, and/or the protection of the safety of any other person or the community, and/or the defendant would not obstruct or attempt to obstruct the criminal justice process, the primary concern being the protection of the safety of the public. The court finds that the state has established by clear and convincing evidence the need to detain this person, that the evidence favoring detention here is so clear, direct, and weighted and convincing as to enable the court to come to a clear conviction without hesitancy as to the truth of the facts at issue. The court makes that determination for a number of reasons, including the offenses charged.
Hey, excuse me,
First of all, let me
Your
just comment.
Can I just say one thing?
Don't interrupt, Mr. Thomas. The offenses charged are terroristic threats. All right, officer, please remove Mr. Thomas. I've warned him a couple times. Mr. Thomas can't even control himself to not speak out during the hearing.
I'm sorry, sir.
Please
I'm not
remove
saying
Mr.
that.
Thomas, officer.
I don't even know what's going on,
Please remove Mr.
sir.
Thomas.
Hold up.
Please remove Mr. Thomas.
No, but listen. He said, listen, I called the lady.
Please
the lady
remove
called
Mr. Thomas. Mr. Thomas, you're excused.
I had to tell people I got an $80,000 check in my house. Judge Tarantino, what I'm asking is this. Can you please get somebody to get my money out of there?
We're going to put him on mute.
I had 2 checks all over.
You're on mute.
To get my money out of there. Can you do that for me, please? Can you please?
Well, I think they have a protocol. I think they can't. Just the one guy, that would be dangerous. So they have to bring in people. They shut his mic off.
And he turned it
You
back
turn
on.
it back on? Oh, that's funny.
I don't know.
I think he's
He did, he turned it off.
okay. All right.
Mr.
All right.
Almeida, I think, may have been saying something.
Mr. Almeida? You can't hear me, can you?
I'm here, Your Honor. I can hear you.
Okay.
Sorry, I had someone walking
Okay.
in the office. It's my media.
All right. All right. And Mr. Rizzo, can you hear me?
Yes, Your Honor.
All right. Apparently they disconnected the video there. All right. The offenses are terroristic threats, possession of a weapon, and unlawful possession of a weapon. It's a totally unnecessary offense in that the particular circumstances are that the defendant had a dispute over an eviction. He went to the victim's office and threatened the victim with a bat, really something that should never have happened, and was very dangerous to the victims. Police had to be called. The weight of the evidence against the defendant, considering the admissibility of any evidence ought to be excluded, is very strong. It includes the personal observation of law enforcement officers who investigated, statements of witnesses, including the victims. There's a body camera video. There's also a 911 call for help. The physical evidence includes the bat used to threaten the victims. The history and characteristics of this defendant is very concerning. His past conduct and his history. He's 53. He's a career criminal. Starting at age 18, he has 43 prior arrests and 38 convictions. His criminal history is reflected in the Public Safety Assessment NS4, and his record concerning appearance in court proceedings is not a good one either. The nature and seriousness of the danger to any other person or the community that would be posed by his release is a big concern. He is dangerous. He's a dangerous and violent individual. He takes matters into his own hands. He does not trust the legal system, but he prefers to impose his own will to get his way. And I wrote that before our little temper tantrum, I'll characterize it, at the end of the hearing by or not at the end, but the end of the presentation of attorneys by Mr. Thomas. He insisted on interrupting. He went into a rant. We muted him, but he was ranting, and they finally shut the video off. I think that the officers had to get back up and have other people to remove him, which is unnecessary. But even in a jail, in a room by himself with one officer with video cameras, Mr. Thomas doesn't like what he's hearing or thinks that it's wrong. And after being told not to interrupt a couple times, he goes into a violent tirade. Thank goodness this one was done by video, and he was in a more secure location, because he was done here in the courtroom. I don't know if 2 officers would have been enough. I'm sure they would have called for backup. It would have been an ugly incident. I would have had to exit as quick as possible. The clerk would have been at risk. Property in here would have been at risk. This is a guy who, that's the way he acts, that's the way he handles things, and that's why he's so dangerous. And I'll come back to that with more in a minute. The court is also concerned with the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process that would be posed by the defendant's release. There's a potential for witness intimidation of the victims, who he already has problems and issues with. Apparently they want to evict him, get him out of the living situation, and he's got a problem with that and went over with a bat. Also based on his numerous convictions for obstructing, resisting, and his many different identifiers and aliases. We know that the release recommendation of the pretrial services program obtained using a risk assessment instrument is that release is not recommended. The public safety assessment scores are 4 and 6, and there is a new violent criminal activity flag for elevated risk of violence. As he stands before the court, or as he stood before the court, this defendant has a pending theft charge from when? February 24th, less than a month ago, 2020. He has a pending shoplifting from 2015, not resolved. He has 14 disorderly person convictions, and they're not good ones. 3, well, none of them are, I guess, but 3 for assault, 5 for resisting, obstructing, or hindering. 2 are drug-related. He has 24 indictable convictions, including 7 for aggravated assault. That's a lot of aggravated assault convictions, indictable aggravated assault convictions. I don't know if I ever saw anybody with that many. 9 are drug-related. He has a 2018 weapons and a 3 for contempt or resisting. So clearly somebody's been, his whole life has been out of control. 10 of those 38 convictions are prior violent convictions, and he served 22 jail sentences. And he's had a lot of lengthy jail sentences, yet he's continuing to be a criminal offender. 4 years for aggravated assault, cocaine, and criminal attempt. 4 years for possession of drugs. 4 years for possession of drugs. 5 years with 6 with 5 for resisting drugs and aggravated assault. 1 year in 2011 for contempt violating a domestic violence restraining order, 4th degree. And then 5 years in 2015 for aggravated assault. He's been in jail a lot of times, this guy, and yet he keeps coming back to commit criminal offenses. He also has 6 domestic violence restraining orders, 4 are active final restraining orders, and 2 are dismissals. 12 total failures to appear, which is a lot considering he's been in jail a lot. He has, in his criminal history, has 7 aliases, 7 different dates of birth, 8 different social security numbers. Criminal history shows 3 parole violations. Criminal history shows 1 violation of probation. And really, he's not being deterred from all of his charges, arrests, convictions, lengthy jail sentences, repeated jail sentences, probation and parole. And he continues to commit violent and dangerous acts. And really, if you look at his criminal history, and this is just the wrap up here, his criminal history clearly shows that he has always turned to violence to get what he wants, regardless of what is required by law or its consequences for others or for him. You know, clearly he's not deterred. He's not thinking, well, if I do ABC, I'm going to get XYZ, which includes going to jail. And he has no regard for the safety of people. This is one of the most violent people that we have seen in this court. Stacey Williams, 452 New Jersey Super 16. Judge cannot give greater weight to medical or other personal conditions, only as they pertain to failure to appear in court, risk of defendant posing a danger to the community, or obstructing justice. And actually, if this gentleman was so concerned about his health, he shouldn't go running up to the office where he's afraid of getting convicted and brandishing a bat, causing them to call the police and get these charges. So the court cannot really consider that very strongly at all. For all those reasons, the court will find the state has met its burden of proof, will order the pretrial detention of this defendant, will also direct you before a reasonable opportunity for continued private consultation with counsel. And he does have a right to appeal this order within 7 days pursuant to Court Rule 2:9-13. All right, that's it for that case. Mr. Rizzo and Mr. Almeida.
He's the 569.
Yes, Your Honor.
Yes. Oh, yeah. PIP date May 6th, 9 a.m. Thank you. We have two left, and we're going to not do this before lunch. We'll come back at 1:45. Okay. Antonio Sweat would be the next case. That's your case, Mr. Rizzo?
Yes, Your Honor.
And then we'll have Mr. Means, who's represented by Attorney Joseph Corby, so that you can cut loose earlier, Mr. Rizzo, okay?
All right, thank you, Your Honor.
Judge.
All right, thanks, guys. I don't want to start one with 15 minutes to go before lunch.
Just one logistical question. If you are aware, will there be a new meeting invite sent, or do we click the same link as this morning to get into the 1:45 meeting?
You are asking the wrong person, but probably it's going to be a new meeting.
Yeah, this meeting will automatically shut down at 1, Brandon, so I'm going to email pretrial services.
Okay.
And let them know that we're coming back at 1:45.
All right. An officer at the jail, sir?
Yes.
Can we talk to my officer at the jail?
Yes.
Sir, first of all, are you okay?
Yes, I am. Yeah, thank you, Your Honor.
Okay,
Yes,
I don't want
am.
anybody to get hurt. Sir, we're gonna break for lunch. We come back at 1:45. We'll see Mr. Sweat first, and then we'll see Mr. Means after that. Okay?
Sounds good, Your Honor.
All right, and we'll get it done this afternoon. Thank you, sir. Take care.
All right, see you guys at 1:45.
Pretrial just confirmed they'll send you a new link.
Awesome, thank you.
All right, thank you.
Thanks. I'm staying here for a couple minutes because I'm going to get a head start writing on my orders.
Talk amongst yourselves.
Yeah, talk amongst yourselves. That's from Saturday Night Live, right?